All right, Mr. Lampkin, can you come forward with your dad, please? There was a warrant that was filed, okay? So I just want you to stay calm, and Dad, we're gonna take care of it today. So before he leaves here today, it'll be taken care of, okay? All right, you understand?
Yeah.
So there's no need to get upset. These things sometimes happen, and we're gonna wait for your attorney. We're not gonna send you back or do anything of that nature until we speak to your attorney. Now, what I can tell you is sometimes the deputies want to take you to back because they have to take certain property and everything. So they'll probably do that, but they'll make sure that he has your property, okay? But we'll wait for your attorney, and we won't do anything till your attorney gets here, okay? All right, thank you so much.
Your Honor, what is it? What type of warrant?
It's for a case. My understanding, it's a case related to something that happened at the jail.
Oh,
Yeah,
okay.
yeah. So we'll make sure his attorney comes in,
Okay.
and then you can speak with his attorney.
Okay.
All right? So just
Wait here.
yes, and you may want to call his attorney because it's better to probably get it solved early in the morning than wait for the afternoon.
All right, Your Honor.
Okay,
Surprising to us, yeah.
all right. All right, who's the party on Joseph Matthew Juarez? All right, so we're set today for jury trial?
Yes, Judge, but this is Steve Spears' case, and I understand he's having medical issues this morning.
It's okay, he's here. So I'll see y'all back at 1:30.
Judge, the other issue in the case, Judge, is Dr. Fabian's report isn't ready. It hasn't been done yet. That's been on Dr. Fabian's radar for a long, long time.
Okay.
It hasn't been done. It's a mitigation issue on punishment. So we wouldn't be able to try the case without that report regardless.
All right, well, we'll see him, if we get to punishment. So I'll see y'all back at 1:30.
So if we get to punishment, we're just gonna.
Yeah.
That's the trial.
Mhm.
3 months until we finish this report.
Oh, it should take him 3 months, but I'll see y'all back at 1:30. All right.
Okay.
All right, thank you. Oh, are you ready, Mr. Fredson?
Yes, Your Honor.
All right, Mr. Dixon. Hello. All righty. So, yes, Mr. Featherston.
Judge, it feels like it was last year that I made a request to you to allow me to hire Dr. Murphy, Joanne Murphy, to do a mental health evaluation on Mr. Dixon.
Mhm.
I'm still dealing with her, trying to get a final report. I have another meeting set up with her on the 30th at noon. She went out of town for 2 weeks, and
Is she in town?
she's, I don't know. I'm
All
told, it's a telephone interview with her on the 30th. I'm hoping to get a final report out of her after I talk to her. I have no idea how long she's gonna take to generate it.
I'm gonna want you all back here by 11:30, and I need a time of when she's gonna do this. And if she can't do it, then maybe somebody else needs to do it. Because,
Judge, I don't want to step back that far.
yeah, I know. So I'll have y'all back here 11:30, and I need a specific date from her.
For completion of the report,
Mhm.
I will ask. I'll call the
All right.
staff now.
All right,
Okay.
thank you.
Thank you, Your Honor.
Who is that? Oh, well, he'll be going to trial maybe in the orange. Mr. Dixon, I told you about refusing the address.
Judge, I'm waiting on a call back.
All right, thank you. And can you express to your client, because he's not listening to the court, that he will be tried in an orange jumpsuit? We're not doing this thing. This is the second time where he's been asked to dress and he refuses to dress. So his case will be tried in an orange jumpsuit, and you can handle that however, you want to handle it with voir dire.
Judge, I'm going to have to take the majority of the responsibility for that.
Mhm.
I need to get him a new set of clothes, and I
Mhm.
need to do a clothing letter and go do the exchange.
Mhm.
And quite frankly, I did not do that because I'm dealing with Dr. Murphy.
Mhm.
So really that's more on my back than I think it's on his back. What he was arrested in is just not appropriate for court.
Mhm.
Okay.
All right, thank you.
Thank you, Your Honor.
Okay.
Totally missed that.
Yeah. Judge, may I approach? Or I
Yes.
guess may we approach?
Yes.
So on this pretrial violation, I was looking over it and it says the positive test was on November 15th, 2025, which is in the future.
Yes.
So
Well, sometimes we look to the future as opposed to past.
Yeah,
I think this
Yeah,
test
they do that.
is a clairvoyant.
because they even put it on there right
So
there.
I'm not sure how to, I mean, I would need a clarification on the positive date before.
Yeah.
That's why I handed over to you all. Well,
Well,
if
she
you all,
found it, I didn't. I'm like, I'm already in beg mode. and-
all right, if you all want to, because I do have to address the violation
Yeah.
report, I can email the pretrial officer
Yeah,
and
Just to confirm the
Yeah.
date and then we can make our
Yeah.
decision.
because all of
I-
these,
and
they
for
want
the
you to address and
Judge,
put
I
it in the
have
system.
not had any contact with her, so I don't know,
Okay. All righty.
Thank you, Judge.
Sure. You know what I can do? I'll just have Norma set it for a hearing, so
Yeah.
you'll get contact because they'll come in.
Yeah,
Okay.
okay, thanks. That's good. idea.
Welcome. Anthony Carrizales. Antonia.
My bad.
No, I'm the one who said Anthony first.
Okay, I'm also still waking up. So. Okay, that's right.
All right, let me see what we have here.
Awesome.
Oh, I pulled up the wrong case for me. Just 1 second.
Got the cost number right.
Oh, no, the cause number is on the docket. All right, so where are we on this case with discovery?
First sitting, Judge, I'm still reviewing it. I will let you know, I've received some medical records, from the family. My client's been found incompetent before, so I need to do a motion to make sure he's evaluated for this case.
Okay. All right, when are you gonna have the motion, Paul?
I'll do it today.
All right. All right, Ms. Ferguson. I need this case recalled at the beginning of December. All right, we'll see you back on December 2nd. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court. All right, just have a seat. Your attorney will bring the reset form to you. All right, the court is calling 2023 CR 10024, State versus Reginald Tyrone Green. Can I have parties approach and announce for the record?
Lauren Espinoza for the state.
Good morning, Your Honor. Bernard Campion and Andres Campion for Mr. Green.
All right. All right, and are you Mr. Green?
Yes, ma'am.
All right, you're here on a motion to reconsider sentence?
That's correct, Your Honor. The court
Yeah.
may recall a few weeks ago, he was here on a revocation proceeding. He pled true. There was an agreement with the state for a recommended sentence on his revocation of 6 months in the state jail facility.
Mhm.
Obviously, that's not binding on the court, and the court's view of the circumstances at the time was such that I think the court assessed a 14-month sentence, if I'm not
Yes.
mistaken. You may recall, Your Honor, that the defendant's father was here and provided testimony about his mental health issues and some of the circumstances regarding the underlying offense. It's an unauthorized use of a motor vehicle, which involved his parents' car. In talking to the parents, it's not something they were excited about pursuing, but we didn't represent him on the underlying charge, so here we are. The situation arose that after the father's testimony, I think the court was inclined to reconsider if there was some documentation that would have supported or maybe corroborate the mental health circumstances that he had been encountering in his life. And also, I think there was submission at the time from probation that he had not accomplished anything while he was on probation.
Mhm.
What we have tendered to the court for purposes of reconsideration are medical records we were able to obtain from the University Health System.
Mhm.
You may recall his parents had him involuntarily committed at one point. These records we've obtained kind of, I think, demonstrate to the court some of what Mr. Green has been dealing with. On page 2 of the records, I think of the medical records, page 1 is just the cover sheet they sent us, but page 2 has an assessment per EMR of bipolar 1 manic with psychotic features. The other pages we have selected for the court's review kind of corroborate that, go into a little more detail about his bipolar. And really what happened, I think, in history was his circumstances domestically were kind of on the downside. His wife left him He took the kids. He went into a pretty deep state of depression
Mhm.
and precipitated all this stuff. He ended up losing his job, living on the street, picking up shoplifting cases, and here we are. But to his credit, he didn't just completely uh, go off the deep end. He got involved in a church, a ministry here. We have included in as an attachment to today's motion, a letter from the pastor of that ministry, a Blaze ministry here in San Antonio. And she corroborates that he had been very, very active in that church once he joined it. He, not just in the ministry program on a volunteer basis, but he also helped a lot just in the physical plant, the maintenance, just the heavy lifting and toting that is associated with maintaining a property. And so I think his heart has been in the right place. His mind has been anywhere but where it should be. And under the circumstances, his father and mother would love for him at some point when this is behind him to relocate to where they're at in Texarkana. They will provide a home for him, get him back on his feet. He's got a job prospect there that is very promising. And his biggest concern right now is being able to resume some type of productive life, be able to pay child support to his children, and kind of renew and reconstruct his life with his children. And with those things in mind, we're hoping that the court would reconsider the agreed recommendation from the state. It obviously, the court's judgment is what we abide by, and we live with that, and we're grateful for your reconsideration of this matter. But the recommendation from the state wasn't haphazardly arrived at. I think we discussed his whole situation, the underlying offense, the circumstances of his living at the time, mental issues. And so we felt like it was appropriate. And we're hoping the court would reconsider the 14-month sentence that was assessed.
State?
Your Honor, based on what is said, I will echo defense counsel's sentiment that these items were discussed with me prior to us bringing that agreement to the court. However, I would just defer to the court's decision on this
All right.
matter.
Well, what I can tell parties is that once the court enters a legal sentence, the motion for reconsideration, that's really not a legal motion. His only options, and I'm not your attorney, I'm not trying to tell your attorneys what to do. His only option is a shock probation, because the court legally cannot reconsider a legal sentence. So the motion to reconsider will be denied.
All right, okay. Even though we're within the 30-day period, Your Honor, for plenary jurisdiction.
No.
For what it's worth, Your Honor, if I may, it was at the court's recommendation that, and the court did announce that there's not a legal means or method or vehicle to do this, but that the court would consider the new information in that format, and which is why we had filed it at the request of the.
We can go off the record. My suggestion is a motion for shock probation.
Got it, understood.
Okay. Thank you very much. Thanks, Jeff.
All right.
Thank you.
And now with regards to shock probation, depending on how long he's been in jail, the court will consider that.
Thank you.
All right, you're welcome. All right, good morning, Ms. Holmes.
Good morning.
So how are things going?
Judge, so, I explained to Ms. Holmes what happened the last time she was here via Zoom. Total accident, confusion. I was not here, so we didn't get anywhere the last time we were here.
Okay.
So, she's understanding that, and Ms. Holmes has been doing very well on probation. Her probation officer doesn't have any concerns at this time. She has secured employment. She, I believe a couple of months ago when she was here, we gave the court an update that she secured employment. She tells me this morning that she will be moving into a new place this weekend. There was some concerns of her testing positive our last time here. Because she did a vape or something. She has then all of her levels has gone down. The very last UA that she submitted in the system is showing that she was negative.
Mhm.
I did speak with the state in regards to her GPS. The GPS, she has not had any issues, no concerns or anything. She is on tracking right now. So we are going to request possibly if we can get that GPS taken off. There's not been any violations or anything there. I did speak with Miss Alban, and she is not opposed. In addition to the GPS removal that we're asking for, we're also asking that she be able to report monthly versus bi-weekly. At this point, she's reporting to her officer every 2 weeks. So we're asking that we switch that to maybe monthly. Ms. Holmes, did you want to add anything to that?
No, no, ma'am.
All right. So are you excited about moving into your new place?
Yes, I am. I'm not happy about the bills, but I'm excited to move.
I'm telling you, the hardest thing about moving to a new place is putting stuff on the walls, you know. And once you make that whole, you know, I always see these other people who do interior decorating. There's supposed to be a way where you can hang a painting without having holes everywhere.
Mhm.
Mom and I don't do that. You know what we do? You know, the guys, well, some guys, they want to take out the measuring tape. My mom would always say, get out of my way. And she just do that. And it's like, yeah, it's in the center. So good luck on hanging your paintings. All right.
And
So
I'm sorry, Judge,
Yeah.
I forgot one thing. Ms. Holmes also receives SSI because of the government shutdown. She's not been receiving those funds. But she is still working, and once she's able to maybe receive those funds, get settled into her new place and so forth, is when she can actually start making regular payments. She did make some payments. I believe I heard that I saw that maybe the complainant or the victim in the case was calling our officer asking about the restitution. And we're trying to get there.
Okay. All right. This is what I'm gonna do. I'm gonna order the removal of the GPS, but probation and state, I'll give you till October 30th to reach out to the complainant to let them know that the GPS will be removed. Then the other issue you were asking for, the court will allow monthly reporting,
Thank you, Judge.
and that can be done by Zoom or in person. Is there anything else?
Not at this point, Judge. She did do her anger management class. There were some issues with being able to pay the final amount. We did confirm she completed it. It's just we don't have the certificate because of the payment.
Okay.
So she is making progress. As you can see, she looks light. I told her she looks lighter and just more refreshed.
Yes.
And I just gave her kudos on that.
All right. Yes, you do look lighter. There's a shine to your eyes. That's what I always look for.
Thank you.
All right, so this is what we'll do. I'm going to have you back by Zoom for your last check-in with me. And then after that, if you want to check in with me to let me know how you're doing, you're always welcome to do that. So what I'm going to do, since I'm having the GPS removed, now the GPS will be removed, but at the latest October 30th, that's to give the state and probation time to reach out to the complainant and let them know that the GPS is being removed. And then we will call you back. Ms. Abrams, is December 2nd okay?
That's Judge.
All right, so we'll have you back on December 2nd, and that will be by Zoom to check in with you.
Okay.
And see if you have paintings up.
Hopefully, I've seen a lot of DIYs, so I'm trying to get into that.
All right, well, have a great rest of your day, all right?
Thank you. You too as well.
All right.
Can you go in, can you put her in breakout?
Oh, she wants you in a breakout room, so I'm gonna put you in a breakout room so she can go over things with you.
Okay.
Thank you. Anyone else ready? Who's here on Jorge Morales? Oh, did you need to be placed in, Ms. Abrams? Once you join, I'll put you in the breakout room. Court is calling 2025 CR 008290 State versus Jorge Morales. Can I have parties announced?
Lauren Espinoza for the state, Melissa Christian for the defendant.
And are you Jorge Morales?
Yes, ma'am.
Counsel, have you received all discovery? And did you review it with your client?
I have, yes, Judge.
Court will counsel. Court will find that the state is in compliance with discovery. Ms. Morales, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Counsel.
Yes, sorry.
Ms. Morales, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance penalty group 1 grams to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? You're gonna need to speak up so the
Oh, yes, ma'am.
counsel, has your client been able to provide you with any defenses?
He has it.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I did.
Mr. Morales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's $1,000 fine. The state is recommending community supervision. They're taking into consideration 2024 PF 20631. Did you understand that to be the plea?
Yes, ma'am.
Yes, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There'll be a TAP evaluation, 200 hours of community service restitution, the DOEP and MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State offers States Exhibit 1 in all attachments.
We have no objection.
State you may be excused.
Thank you, Judge.
All right, off the record, yes. Let me see. Oh, you're in number 2. You just have to go there. Oh, let me see.
Okay, now I am.
All right, thank you. We're back on the record. Mr. Morales, did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we just like you followed the plea bargaining with state's recommendation of probation.
All right, so sir, Mr. Morales, who is Victor Hugo Lamont Sanchez to you?
My ex brother-in-law.
Okay. Do you have any children?
Yes, teenagers.
All right, do they live with you?
Yes, my oldest is 22.
And what do you do for a living?
I was in construction, but I got hurt, and I haven't been. They've been paying the bills right now, so but I need to go back to work.
All right, so is that workers' compensation or something else that's happening? Unemployment?
Nothing. I didn't file for nothing. I don't want to.
Okay.
I don't like taking nothing from.
Well, so just as a side note, people see that as taking, but if you're hurt on your job,
Yeah, but
somebody's supposed to pay for that. Too many times people have this idea, oh, I'm hurt on the job, then I'm just gonna let it slide. When if you let that slide, who knows, maybe there's something wrong with safety standards there. And if you just let it slide, then the lack of safety standards will continue.
but it's a lot of paperwork. It's a lot of they ask this, that, this,
All right, this is what the court will do. The court is going to sentence you to 5 years in the prison, suspended and probated for 6 years. If you're drug tested today, what will happen?
I'll probably come out there,
All right, how often are you using?
maybe like every 2 weeks or so, but
And what are you using?
cocaine and alcohol.
All right. There's going to be regular reporting by Zoom or in person. Regular random UAs. I want a referral to felony drug court. A TAP evaluation out of custody. If he's not accepted into felony drug court, then follow the recommendations of TAP. Take in consideration 2024 PF 20631. There's $1,000 fine. That will be probated. Proof of employment within 45 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. No contact with Victor Hugo Lamont Sanchez. Field visits 1 time per month for 6 months. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. And there's going to be 30 sober meetings in 30 days. Probation, is there anything else? Is there anything else you need from the court to be successful?
What's the parenting classes?
Oh, that's where you learn how to parent, right? And sometimes people will say, well, I know how to parent.
But I have no kids. It doesn't matter. They're small. They're not
Yeah, you
small.
said they were
Yeah, there's
teenagers.
22 and 20,
So let me just
24,
tell you,
26.
usually when people have children in this court, I do parenting classes.
Yes,
You know
ma'am.
why I do that?
Yes, ma'am.
Because sometimes people don't understand that your drug addiction,
Yes.
you're picking up, these charges impact the children.
Yes, ma'am.
They just think, well, I didn't use it in front of them, so it's all fine.
Yes, ma'am.
But all of our actions as an adult impacts our children.
Yes, ma'am.
And so parenting classes are going to teach you that. I always tell people, maintain your sobriety for yourself, but if you're at that stage where you can't do it for yourself, then maybe having that parenting class will make you do it for your children.
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. In this court, communication is key to be successful on probation. If there's an issue, let probation know about it.
Okay,
If you feel they're not addressing it, you can always come back to me.
okay.
If you feel you're gonna use, call probation. I know some courts, people say you can't do that, but in this court, if you call probation and say you're thinking about using, you know what's gonna end up happening? I'm gonna set a compliance hearing. We're gonna come in, we're gonna try to address that to get you some help.
That's
But
fine.
if you don't tell them you need help or you're doing things in secret, nobody can help you.
Yes, fine.
All right, good luck to you, okay? And thank you for dressing appropriately for court. Thanks, counsel. I love your pen today.
I work for you.
Court is calling 2025 CR 55792. State versus John Castro Lopez. Can I have parties announced for the record?
Jeffrey Wright for the state.
Rafael Leal for Mr. Lopez.
And are you Mr. Lopez?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, sir.
All right, and the court will note for the record that the court previously received an acknowledgement of discovery on July 28th, 2025. There's been no new discovery since that date. Is that correct?
Correct, Judge.
All right. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
State moves to proceed on count 1 and waive count 2.
Any objection?
No objection.
All right, off the record. Deputy Lord, could you have them moved? Could you have them to like, not talk so loud? It sounded like it was in stereo coming from this end. All right, we're back on the record. Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, your charge is possession of child pornography younger than 10 years of age. As a first-degree felony, the range of punishment is 5 to 99 years or life and up to life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Judge.
Mr. Lopez, does anyone threaten you, force you, or place you in fear to get you to enter this plea?
Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, you will be deported and not allowed re-entry and denied naturalization. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 12 years in the prison. There are no applications. There's to be Chapter 62 compliance, and there are no contact with that to be the plea. Defense,
Yes, sir.
state?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? You're gonna have to speak up so she can hear.
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and attachments.
No, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty. All right, so why should I follow this plea?
Well, Judge, my client has taken responsibility. He's fully admitted to his actions. Did not play games with the district attorney or the court. He's, I think he's doing that, right now, as opposed to, dragging this out and making, the witnesses and the, other people involved, to be in court and present testimony. I think it is an appropriate, sentence, given the circumstances, and also my client has not, other, convictions, no meaningful criminal record of any kind, Judge.
All right. And then this no contact order that's outside your agreement, that's his child?
Yes, Your Honor.
All right, but isn't there, according to this, on this page,
His child, the child went through a forensic interview and did not, provide any.
but there's the photo of his child, so that would be a no.
Okay.
And if that's a deal breaker for anybody, then you can always go to jury trial. But
I explained that, to my client, George, and we're willing to proceed.
all right, the court is going to sentence you to 12 years in the prison, give you credit for any time served. Chapter 62 compliance. There's to be no residing in households with minors. No contact with minors. There's to be no contact with anything else with regards to sentencing?
I don't know if I missed it, Judge, but this is a 42A.054 offense. Because it occurred after September 1st, 2023.
Yes.
Okay.
Is there anything else?
Not from the defense. Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. You said there's victim impact?
Yes, Judge, I'll just be reading it off.
Okay. Court is calling 2025 CR 006-729 State versus Jesse Orozco. And Norma, find out how many witnesses they have on Miller. All right, and where's your client?
It's in the tie. I'm over here, I think.
Okay, ask the state how many witnesses they have. All right, are you Mr. Orozco?
Yes, ma'am.
Counsel, have you received all discovery that you review with your client?
Yes, I have, Your Honor, I have.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Orozco, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Judge, we are waiving the punishment.
Any objections to?
No
the-
objections.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge is possession of a controlled substance, penalty group 1 less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe so, yes.
Mr. Orozco, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
Yeah, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand by entering this plea, if you're not a US citizen, you will be deported, denied naturalization and reentry?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 60 days in the Bexar County Jail. Under 1244, there are no applications. There's to be restitution of $180 to DPS for testing. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then how do you plead to the offense?
Guilty, Your Honor.
State, any evidence?
State offer states one in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client has been sober now for a few weeks. He started taking care of himself that way. He's willing to do the time, and he's set up meetings with AA. He's got a sponsor now. Is that right?
Yeah, it's a good month.
But I think that he just wants to get this time done and then move on from there. Your Honor.
Anything you wanted to tell me?
I'm just, I made a mistake. I wasn't making wrong choices at the wrong time, Your Honor. I'm fully accountable of my mistakes, and I'm trying to get past this and move forward with my life.
All right, and how are you maintaining your sobriety?
I've been attending AA meetings at the Club 12, Your Honor, and I've asked everything of the pretrial investigations of me to be doing as a monthly UAs. I've passed every UA. It's been 12 months now. I have not failed one time. I had my head in my rear end at the time, and I fully accept consequences of my actions.
And so how much time does he have in?
9 days.
Okay. All right, so they're going to take you into custody today, okay?
Yes, ma'am.
All right, the court will follow your plea, sentence you to 60 days in the Bexar County Jail under 1244, give you credit for any time served. There's to be restitution of restitution of $180 to DPS for drug testing.
Okay.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing. First of all, I want to thank you for dressing appropriately for court. Even though you knew you were going into jail, you still dressed appropriately for court, and I really do appreciate that.
Well, Your Honor.
With regards to your sobriety, don't let anybody get you off track with your sobriety, right?
Yeah.
when you're released from custody, if you have any problems, you can come back here, okay? And then I'll pick up the phone and find someplace to help you, all right?
Thank you, Your Honor. I appreciate that.
Now, here's the thing, the jail, if you're a trustee, they're supposed to give you credit. Every day you serve, they give you 3 days credit. If you're just in general population, not causing problems, every day you serve, you get 2 days in credit. I'm not in charge of that. So if they're not giving you credit for 3 for 1 or 2 for 1, you just have to address that with the sheriffs because I have no jurisdiction over that, okay?
Thank you, Your Honor.
All right, good luck to you, okay? I'm
Thank
so
you, Your
glad you look clean and sober. I like it.
Thank you, Your Honor.
You're welcome.
Appreciate it, Judge.
Dejanay Miller Havana. All right. Court is calling 2025 CR 001454, State versus Dejanay Miller Havana. Can I have parties announced for the record for the state, for the defense?
Jody Sawyer's for defense.
And are you Dejanay Miller Havana? All right, you entered a plea on September 30th of no contest. According to your plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. The state is opposed to your application of deferred adjudication. The state is recommending community supervision. Outside the agreement, there's a request for your community supervision to be for a term of 10 years. And of course, community service hours and different programs. Have both parties had a chance to review the PSI report and the TAP evaluation?
No,
I have.
Oh, you have not?
no, Judge. I
All right, so I'll have you all step back. So if you can review that and just come back up once you reviewed it.
Excellent.
All right, thank you.
Judge, I have 2 short witnesses for the court.
Right. Court is calling 2025 CR 008569 and 2025 CR 008203. State versus Robert Luis Moreno II. Can I have parties announce?
Austin Stott for the state.
Jim Oltersdorf for Robert Moreno.
And are you Mr. Moreno?
Yes, ma'am.
All right. Objection, sir, to appearing by Zoom?
No, ma'am.
Defense, do you have any objection to your client appearing by Zoom?
No, Your Honor.
All right, according to your plea bargain agreement and cause number 2025 CR 008569, punishment is being assessed at a cap of 13 years. And cause number 2025 CR 008203, punishment is being assessed at a cap of 13 years. And each cause number, the state is opposed to your applications. All right, both parties waived the PSI and the TAP evaluation, is that correct?
Yes, Your Honor. We were present about a week ago, I believe. I can't remember the exact date.
That's my
And that's what we did.
All right, defense, I'm sorry, state, do you have any witnesses?
No, Your Honor.
Defense, do you have any
I
witnesses?
do, Your Honor. May I call my first witness?
Yes.
Mom, could you come up, followed by Joanna, I guess? It's okay, don't hurry. Right in this spot here.
Hi, I see that you're limping. Do you need a seat?
No, it's no. It's just something I'm good with.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
My name is Joanne Esparza.
All right, you may proceed.
Thank you. I'm sorry, I mixed up the names
That's
again. Now, you're Robert Moreno's mother, is that correct?
That's correct.
And of course, I want you to make sure the judge can hear that. Right?
Yes,
Yeah,
that's
so
correct.
voice.
Robert Moreno's
Now,
mother.
Robert has been in court and he's been here present in person before in the courtroom in a wheelchair. Can you tell the judge what his medical condition is?
Robert was born with spina bifida and hydrocephalus. He's been paralyzed since birth. He's had a VP shunt he had reconstruction on the spine that stayed paralyzed. He's had a VP shunt in his head. 3 months, a replacement at 9 months and 9 years. And the doctor stated that there would be like maybe 3 replacements throughout his lifetime.
I'm sorry, go ahead.
Robert has always been a sickly person, sickly child, in and out of hospitals, surgeries, doctors. The last one was the worst one. He's had a tailbone surgery from not being in a proper wheelchair, which we had to fight to get. And I've always been his caretaker. I've always taken care of him, nursed him back to health. And the last one was the gas gangrene. He's got incontinence problems, which he takes medication for, but he still has some leakage problems and has problems with his bowels. With the leakage, I guess it broke his skin and he winded up getting gas gangrene. They did a flap surgery in his groin area and abdomen. And while he was here in jail, it reopened, and that's something that we always have to look out for, like a tissue breakdown. He has problems with his bowels as well. Like I said, I've always been his caretaker, along with my sister being my right hand, you could say, his second mother. And I just want to let y'all know, I plead for mercy that if in any case he'd be able to be on probation, he reside in a home where there is no children, no internet, no use of a phone. He'd be under supervision at all times. I work in the morning, my sister works at night. We don't know how something like this could have occurred. We didn't see it coming, and it came as a shock to us. We only knew the very minimum. And we would like to get him help with counseling to resolve this problem. But he's always going to have health issues. He's always had health issues, and how he's done it by so far, I don't even know, because I've always had to even help him bathe, cut his toenails, and look out for pressure sores. I've always been the one.
What kind of work do you do right now?
I work in fast food.
Okay. Judge, I have tendered to the state medical information. I'd just like to be able to have it in the hands of the court to more or less verify. It's recent. That's what I was asking. I didn't want to get piles and piles of information. We have a lot that goes back a long way. I wanted you to at least know that his condition is not temporary. In other words, it's not something that somebody has come into court and said, well, Judge, I need to be on probation. And then they more or less get up out of the wheelchair once they get what they've asked for. This obviously, based on what the medical stuff that I have, this is, like I said, it's been provided to Mr. Wright, not Mr. Stout, but it's in their file. Verification of the spina bifida, which, as you know, is the a child born with the spine outside the body. And it's not something that's, going to go away. So his mobility is, of course, limited. And of course, I can't absolutely, and I've gone over this at length with his mother and the next lady that would ask you for your attention. How did this happen? And again, told them that what the court would expect to know is that this could never happen again. So I think we've at least closed off one avenue for purposes of any question of being a sexual predator. If he doesn't have the ability to go out and go to places, schoolyards or out in the park or anywhere like that. So the next question, of course, in my mind for a judge that I would want the judge to know, and I know always consider, first thing we think of is, well, if it happened before, it can happen again. And I've tried to make sure that she understands, and she seems competent as far as her insight and explanations and knowing that cannot be explained away, but it has to be stopped. And because it is something that might continue, we want to make sure that any communication that would enable him to do anything like this would be cut off. And she is here to tell you about that and to try to promise you that. The only thing that I can't stand up here and make sure that you know about is we're not really sure what to do with regard to some type of 24/7, because as you've heard, you do continue to work, correct?
I work in the morning and my sister works in the evening.
Okay.
Would there be any time,
That he would be alone now.
yeah, okay. So the judge can be assured that someone will be there to not only take care of him, but to prevent him
Correct.
from being on the internet or having phone contact.
We have no internet to begin with, and he wouldn't have any access to any telephone.
Okay,
Because
so-
he would always be under supervision, so we'd always,
So before, when there was a need maybe for a telephone, I'm just guessing here. If someone's in a wheelchair, let's say a fire breaks out, things could come up where they would need to contact 911, for example.
correct, but he'd always be supervised.
Okay, so there wouldn't be a need for that anymore because he would never be left alone. That's the assurance you're giving the court?
Yes.
Thank you. Pass the witness, Sean.
Any questions?
Yes, ma'am. I'm the prosecutor in the case, Mr. Scott. Just a few questions. You were Mr. Moreno's mother?
Yes, sir.
Okay. And back when this incident occurred, he was around 19 years old. Are you aware of that?
No.
What is your understanding?
I understand it was several years ago. 2018, 19, 20, about that time. And as far as I knew, I thought it was just contact like on the phone, like they were talking and stuff like that. So when the attorney spoke to me about everything, it came as a quite a shock I didn't have.
So at that time, was he residing with you primarily?
Yes, he's always beside me.
What was he doing at that time? Was he working, going to school?
Going to school.
Okay. And how are you related to the victim in this case?
She is my niece.
And you understand that she was 9 years old when this happened?
I don't remember what her age was. They had told me that she was, I think, 13, is what I had heard.
I'll pass the witness.
Well, just to make sure you're completely
Yes, but I
aware.
understand what was written.
Okay,
Yeah,
you understand, you and I have carried on
Yes.
many conversations about the discovery, meaning
Yes.
the DA's
Yes,
file.
everything that's come out.
Okay, so
Correct.
you're basing your information now on
On what I,
what you discovered and how to prevent it from
Yes, sir.
happening again, correct?
correct.
Thank you. May I call my next witness, John?
May I?
Oh,
ask
oh, yes, Judge, I'm
Any
sorry.
objection?
There you go.
All right, so
Oh, miss.
Oh, yes, ma'am.
no. I want you to understand something. One,
Yes,
you
ma'am.
keep it in an open mind and I'm listening to everything. But sometimes when people are called as witnesses, they're asked, oh, how can you make sure that this person follows the rules? That's really not your job. It's the person who is on probation to follow the rules. And so according to the stipulations that I've read, this started when she was 7. And then the photos that are in the stipulations is that they're saying they're photos that depicted young children and infants. Now, with regards to the infants, I don't know if that was pornography or sexual in nature, but that's what it says in the stipulations. And that's when they said they were making inquiries as to what was the age range for his sexual interests. So I just want you to understand that I'm listening to you, but I'm also, I've also reviewed the stipulations as well. So none of this is your fault. And your testimony gave me great insight to his medical issues, okay?
If I may add one more thing, Judge.
Sure.
I've had no contact with my niece nor her family since all this first came out.
Mhm.
But I still love her, I still care for her, and I do hope that she is getting some kind of counsel for it,
Because in the
I know
stipulations.
how drastic it is.
Yeah, because in the stipulations too, it says that he continued to reach out to her. And then there was some blocking going on. So I
That's
just
what I
want you to understand the full extent of things and everything that I'm considering, okay?
Yes,
But thank you so much for your testimony. I appreciate
Yes,
that. Thank you.
God bless you.
Oh, thank you. God bless you too. Call your next witness.
Where are you?
Hello, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Judge.
All right, you can lower your hand, state your name for the record.
Rosemary Esparza.
All right, defense, you may proceed.
How do you know Robert Moreno and his mother?
He is my nephew and she is my sister.
Okay. Now, I don't think you could hear from back there, but we were talking about things that I've talked to y'all about, both of you about previously, about how can we give some type of reassurance to the judge with regard to controlling this contact and with anyone. You understand what I'm talking about, remember?
Yes.
We discussed it more than once, last time in the witness room a few weeks ago. She was talking about, his mother was talking about monitoring, and we realized that it's something that would require more or less 24 hours supervision. You know what I'm talking about?
Yes.
Can you talk to the judge a little bit about your ability to be a part of that, and maybe what your hours could be, what you've talked about with your sister, about what needs to be done to make sure this doesn't ever happen again with anyone?
Judge, basically, she clarified everything. I know we're not above the law, no one is, but I do pray for my nephew and my niece.
Do you, excuse me for interrupting, do you work?
Yes, I work at night
Okay,
and my sister works in the day.
okay, so
We,
I'm sorry, just to take it from that point. We were talking about a 24-hour day situation.
yes.
Do y'all live together?
No, but during the time before Robert Lewis got arrested, he was staying with me. He
Okay,
was living with me. My sister would come and stay with us. And we've talked about it. If it came down to it, that I would be willing to open my home to them.
okay. So are there any children in your home?
No,
Okay,
there's no children, no internet.
so it would be the three of y'all, Robert, your sister and you, or do you have a husband, or how does that work?
And my father,
Your father, okay. So you work at night. What kind of work do you do?
I'm a housekeeper,
Okay.
hospital,
At where would that?
Santa Rosa,
Where?
Santa Rosa,
The Santa Rosa Hospital? Okay, thank you. How long have you been doing that?
9 years.
9 years. So that's from what time roughly in the evening do you start and when do you get off?
I start at 3 and I finish by 11:30.
Okay, so 3 PM and that's in the afternoon,
Yes,
11:30 PM at night, right
Yeah.
before midnight?
Right.
Okay. And so you could come back home after that and monitor Robert and make sure, like you said, there's no internet and he has no phone. Is that correct?
correct.
Okay. So he would be cared for, and his medical condition is something that you have probably been aware of for his whole life too, correct?
Yes, correct.
What would that be? What is his medical condition? Do you understand it?
Yes, I understand it. He has spinal bifida.
And that is something that he was born with, or did it?
Yes, sir. He
Okay.
has spinal
So his whole life he's been in the
wheelchair bound.
condition that he's in now, except he's had different medical issues come up, I believe too, right?
He's always getting sick. My sister's always in the hospital with him.
Okay.
Mm.
So I'm not going to ask a lot more. I'm just trying to make sure that the judge gets the picture that, of what is visualized here, which sounds like the assurance that she's got that he's not going to be in a position, even if he wanted to do this again. And do you know, one more thing, do you know the niece that we're talking about here?
Yes, I do.
How do you know her very well, or?
Very, very well.
Okay.
I practically raised her.
Okay. And you know about the facts of this case, and you were surprised as well, I believe,
Yes.
correct?
Yes.
Okay. Now, as Robert goes forward, we hear about things like bed sores or whatever. You sound like you might be familiar with that if you work at Santa Rosa, right?
Yes.
And you've been involved in as a housekeeper, are you involved in helping people in a nursing situation or just what is the extent of your duties at Santa Rosa, just briefly?
No, so it's just securing, the safety for
Okay.
patients and.
Okay. Do you deal with patients at all?
No,
Okay. But you're totally willing to help
yes.
in any way with Robert's medical conditions, no matter what they may be, even if it's,
Correct. I've helped out taking care of Robert.
Okay. thank you. The judge may have some questions for you.
Any questions?
Nothing from the state.
All right, thank you
That's
so
all we
much
have,
for
Judge.
coming down.
Thank you.
So I want to let you know, I've heard everything that you've said, I've internalized it. And I'm considering everything and in reading stipulations. Even though he has these medical conditions, you're aware that according to the stipulations, he did engage in physical contact with her. And according to this, he also threatened, according to the stipulations, he threatened to go after her younger cousin if she didn't send him photos and if she didn't do other things. You're aware of that? Okay, all right. Thank you so much for coming in. I appreciate it. Yeah. Any other witnesses?
May I ask Mr. Reno to
Okay,
explain briefly?
all right. If you can unmute yourself, please. You want to raise your right hand? You solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Robert Moreno.
All right, defense, you may proceed.
Thank you. Robert, you've been listening to your mother here today. And how do you feel about you've admitted that you by entering a plea, even though it may be no contest, you've admitted that you've done these things.
Yes, correct? I'm on the case from like 2004. Correct. But I got like 20 months left on parole.
Do you feel like that you did something wrong that you shouldn't do again? Can you hear me?
I do. I'm deeply ashamed. I promise I won't do anything like this again.
Do you have?
I'm sorry, you're breaking up a little.
Okay, well. Robert, with regard to being on probation, is there anything you'd like to say to the judge before she makes her decision about why you should have a chance to be on probation? Will this ever happen again? Are you sorry? Tell her what you think about everything that's going on here in your life with regard to this offense.
Right. Well, as I said, I am deeply ashamed of my actions. I was young. I was very dumb. I made mistakes, and like I said, I'm ashamed of my actions. I feel for my family as well. As they said, this came to a shock to them, and I apologize to them, for putting them in this position. I want to thank my family for standing by me through this situation as well. As for your consideration for probation, I appreciate you taking into consideration everything, Judge. As my family said, they would set up a scenario where I would be under their supervision practically 24 hours a day, no internet, no phone, no way of contacting
Robert,
victim or anyone that could be a victim. Yes, sir.
Robert, with regard to your medical condition, kind of on a timeline going forward and using the past as a reference point, are you receiving the kind of care in the jail that you had received before you were put in jail?
Not to the extent that I was previously to jail, no.
What, without getting into details.
I have been receiving care, but it hasn't been.
Pardon?
Oh, if you could repeat that last answer, sir?
Well, let me ask it again. Are you receiving the kind of daily care or whatever is required that you were receiving outside, are you getting the same kind of care and attention as you were in jail with regard to your medical needs?
Not to the extent that I was before being arrested.
What, on a weekly basis, just a kind of an overview, do you need something done every day with regard to you being assisted in your wheelchair since you're paralyzed?
Yes.
Is that happening? I'm sorry.
I use stuff catheter.
I understand. It's okay to talk. We need to know.
Catheters. I use them daily, in and out catheters.
Okay.
I also, and sometimes those, the nurse will skip a day, won't be able to supply them for that day, or I'll ask and they'll get busy. So usually I won't, every once in a while, I won't get what the materials that I need in order to make sure that I can remain healthy.
Is it harder in jail, just taking away the fact that you're in jail, is the medical attention, is it less than you received on the outside, even though they try to keep up with what's your needs are?
Yes, I understand that they have other inmates and other patients that they have to tend to, so the amount of care that I receive personally is not to the extent that I received before jail.
Okay, I know you're getting medication. I've checked on that, correct?
Yes.
I'm talking about other types of things such as cleaning and the like, medical attention.
Yes,
That's good or bad?
It's not to the extent that I wish it would be, the way that it was before.
Not the same as with your mother and your aunt.
Correct. My family was much more thorough, and they would be able to be more thorough and keep my health in tip-top shape.
Thank
Whereas
you.
here, I would just like to mention that I've had several breakdowns, not just the one that my mother knows about. So I've been receiving wound care here and there throughout the 8 months that I've been here.
It was just a request, like a little request.
Do you require outside doctor care that you have or have not received?
Yes, I have well, like I said, my mother said I have the VP shunt in my head. If that were to break down, or if that were to be damaged, I would need surgery for that. On top of that, any wound care, we would have nurses that would come and supply the medical equipment and show my mother how to dress a
Okay.
wound.
Now, the BP, what is it? Just real quickly, what does that mean?
So it's from the hydrocephalus. I don't know what the acronym for VP stands for, but basically it's a catheter that goes from the brain down into my stomach, and it allows the fluid to flow properly. Without it,
Okay.
my head would swell up and cause headaches and eventually death.
Okay, so this has to do with fluid from the brain that has to be removed, or what?
It has to flow throughout the body, otherwise it would swell in the brain.
Okay, otherwise the brain swells?
Yes.
And you've had that at least once in your life already, right? Done?
I believe I've had 2 replacements so far.
2?
I believe so.
Okay, it's called a stent, right?
I believe so.
Okay, do they drain it at the jail, or how does it, a stent usually means something is inserted or drained?
So it doesn't need to be drained. What it does is it flows through in and out. And as long as it isn't damaged and there's no leakage, then there's no need to drain it.
Okay,
But if there was damage to the shunt, then drainage would be necessary. And then
Okay.
surgery as well.
Robert, there's a gentleman standing over to the on your screen. He's from the DA's office. He's not Mr. Wright, who you've met, but he might
Right.
want to ask you some questions on behalf of the DA's office, okay?
Okay.
All right, so answer his questions appropriately. Thank you.
Yes, sir.
Pass the witness.
I've never had a.
Mr. Marino, before your arrest, where were you receiving most of your medical care?
Mo keeps pushing. Keep adding
Mr.
that
Moreno?
time you do on the streets, add it back on, you know, I'm like.
Can you hear me?
I've had a felony since 2004.
I apologize.
All
you're
right, Mr.
breaking up, sir.
Moreno, the question from the
I'm glad you
state
know, I'm glad
was,
y'all done it.
before you were arrested, where were you receiving your medical care?
I was, my primary care physician is Dr. Federico Prado. I was receiving care from his office as well as partially through wound care center. Whenever I had a breakdown, they would help us out with that.
And what hospital were you going to for treatment when you needed?
And for the hospitals, I was going to Baptist Hospital.
Okay. And you understand that in the jail, you have a right to the medical care for any
Yes.
issues. You have. Okay. Just going to the facts of this case, I know you stipulated the evidence in the case. And that evidence alleges that you touched your cousin when she was very young, correct?
Right.
On multiple occasions. Correct?
I don't recall.
More than one occasion?
Multiple occasions, but if that's what it says, then.
And well, you would have the best,
I don't
you have
remember.
to be the best person to know that information, correct?
Like I said, I'm from Houston. I'm
Correct.
from Harris County, so.
And how old was your cousin when this occurred?
3 sisters.
From my understanding, she was around the age of 13. But the stipulation state otherwise, so.
So you disagree with that aspect of the stipulations?
Correct.
Okay, and how old were you at the time?
Roughly 20,
Last year.
2022.
And then you've also
Within that
stipulated
range.
that you engaged with her online, correct?
Correct.
I just got.
And
I got
how old
into it
was
with
she
my
when
wife.
that occurred?
Thanks, Lord.
To my understanding, around the age of 13 as well.
Go get an address.
And so it was around the same time?
Didn't do it. You know.
Yes.
Everything just blew up.
Okay.
I was
And
really
your
moving too fast, trying to get into a
your
relationship.
position is that you did
I
not
was
send
just
any
wanting to get
photographs
some
to
of
her,
last
but
year,
that she
matter
sent
of
photographs to
February.
you. Is that my
Everything.
understanding?
Over to.
Correct.
And why would
Yes,
she
that
do
is
that?
correct.
Why would she do that?
I was, for the last time, 5 years, I took 6 class, drug treatment, and I
I
successfully completed
basically
it.
convinced her to do so.
Like I said, I came out running, man.
She, I guess, felt
in trouble
like it was
trying to move out.
necessary. Otherwise, she might get in trouble, or I'd tell someone. I'm not sure.
That was 700.
Okay, so you're the one that made her do that.
I got
Yes.
2 more times to take a test.
And did you threaten her as the
So I
stipulations
came out running. I had a job that
detail?
No, I didn't threaten her.
Positive, no. But when you
Okay,
hang
so
with
that
wrong
would be,
people,
if she
guess
said
what?
that, she would not be telling the truth.
Yourself to
Correct.
do that. And guess what? I've
Do you
had
realize
tools in
the
my-
emotional harm and trauma that you've inflicted on this young woman?
I do.
I blame me.
And
So-
do you have any children, Mr. Moreno?
No,
You know,
I do
I
not.
understand why.
If you did
I
have a
understand.
daughter and this happened to her, would you think that probation would be appropriate for someone that had done that to her at that age?
Get where I'm at now.
Okay, pass
Not
it on.
necessarily.
All right, any other questions?
No, Your Honor.
All right, thank you, Mr. Moreno.
All
All right, any other witnesses for either side?
No, Your Honor.
All right, in cause number 2025 CR 008203, the court will find you guilty, sentence you to 13 years in the prison, give you credit for any time served. There's $1,000 fine, time and money to run concurrent. This is run concurrent with 2025 CR 008569. There's to be Chapter 62 compliance. There's to be no contact with minors, no residing in household with minors, and no contact with the complainant. And cause number 2025 CR 008569, the court is finding you guilty. The court will sentence you to 13 years in the prison, give you credit for any time served. There's $1,000 fine, time and money to run concurrent. This will run concurrent with 2025 CR 008203. There's to be Chapter 62 compliance, no contact with the complainant, no residing in household with minors, no contact with minors. Is there anything else with regards to sentencing?
No, Your Honor.
And each cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Mr. Moreno?
Yes, Your Honor.
Because
Just
these are
go
plea
on.
bargain agreements, because I followed your plea bargain
You
agreement,
sit
and
me
because you
down,
waived your
sit me
right.
down and tell me, look, I got a better thing for you than what you in the
Because
streets.
these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. So I want you to know, Mr. Moreno, your attorney did a great job for you. I did
And
take into
so that I
consideration
see, I never involved myself in
the
it, so I
medical
stayed on
issues that you
the-
have. That is the reason why I didn't ask either party why I should accept your plea bargain agreement. So good luck to you, sir.
Thank you.
Thank you.
Thank you.
All right, the court is calling 2025 CR 0015. I'm sorry, 1454, State versus Dejanay Miller, Havana. Can I have parties approach and announce for the record, please?
Jody Sawyer's for the defense.
And are you Dejanay Miller?
Yes.
I'm sorry, Dejanay Miller, Havana?
Yes.
All right, you entered a plea in this case, and the court has previously stated on the record what the plea bargain agreement consisted of. Where we left off, the court asked if all parties had a chance to review the PSI report. And defense, have you had a chance to review the PSI report?
I have.
State,
Yes, Your Honor.
any corrections to the PSI report?
I have no corrections to the PSI report. I do need to follow up on one thing after the statement.
All right, any corrections to the PSI report? All right, any witnesses from either side?
Yes, Your Honor. State has 3 witnesses.
All right,
So first state calls Katherine Miller.
Okay, then I don't need to go back in.
sure. Yeah. Could you raise your right hand for me, please?
Sure.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Kateri Miller, first name Kateri, last name Miller.
All right, you may proceed. All right, guys in the box, if you could whisper. All right, you may proceed.
Ms. Miller, how are you presently employed?
I am currently employed by the City of Converse Animal Care.
What is or do you have any training and experience relating to animal cruelty?
Yes, I am a nationally certified animal cruelty investigator through the University of Missouri. I've worked in animal care and control and specifically as an animal cruelty investigator for 11 years.
Do you have any continuing education in this area as well?
I have continuing education for the Texas Department of State Health Services as an animal control officer.
Do you have any training and experience relating to the discipline of animals?
Yes, as far as what could be acceptable or determined to be cruel treatment.
Are there preferred? I don't know. So with discipline, right, you said that there was acceptable. What is acceptable discipline mean?
Corrections that would not cause any physical harm to an animal.
So what would be an example of unacceptable discipline?
Excessively hitting your dog or cat or animal to punish it.
Generally speaking, in your training and experience, do discipline methods depend on the age of an animal? Or may they?
Potentially, younger animals that are in development are more susceptible to injury or so having even accidentally hit an animal could cause an injury or puppies or kittens, for example.
And then do methods of discipline depend on the size of the animal?
Not necessarily.
Officer Miller, how did you get involved in this case?
At the time of the incident, which was in January 17th, 2025, I was employed by the City of San Antonio's Animal Care Services as an animal cruelty investigator. I was working on a scheduled day of work when I received an email sent to the Cruelty Investigations Department containing a video which was linked to a report that was made through the city call center or 311.
Did you watch that video?
I did watch that video.
What did you observe in that video?
I observed a 45-second clip of a young adult female African-American woman on a balcony of a higher story multi-unit structure hitting a small breed or small breed size or sized dog multiple times with an object that appeared to be leash-like. In the video, the woman is seen striking at the dog 17 times, 15 of which while she was holding the canine, 2 of which were at the end whenever the canine had been released.
You said she was holding the canine. Could you tell where she was holding the canine?
It appeared in one part of the video to be by the canine's head or muzzle, which would be called the snout, as well as forelimbs. It was kind of hard to see exactly because there was a pop-up crate or carrier that obstructed some of the view.
Did you ever come into contact with this animal?
I did that evening, yes, ma'am.
Why did you come into contact with that animal?
So after I observed the video and I determined in my professional opinion as it being excessive and to be found to be animal cruelty, which is causing unjustifiable pain and suffering to a non-domestic animal, I went and obtained a warrant to remove the animal from the owners or the suspect's custody.
So you removed from her custody and you came into contact with the animal. Can you please describe the size of the animal?
The size of the animal was very small. It was under 3 pounds at the time of the incident because we took it in for an examination at night. But it was very small, easily to be picked up.
Do you know the age of the animal?
I believe he was a 3-month-old miniature or toy poodle.
Generally, in your training and experience, are there behavioral manifestations exhibited by an animal when they're experiencing pain?
I'm sorry, could you ask the question again?
Of course. So in your training and experience, do animals manifest when they are experiencing pain?
Yes, they can.
How can they do that?
They can do it by crying out, limping, acting abnormally for that specific animal. But at the same time, they often mask pain as well. So you may not know that an animal is exhibiting pain all the time.
In the video that you observed, did you see any of these manifestations?
Yes, there were times in the video, for example, you could hear the puppy whimper and the woman in the video tell the dog to shut up. And then at the end, whenever they went to strike at the dog while it was loose, the dog screamed out as if it was in pain and fear.
So based on your investigation, did you develop an opinion as to whether the puppy in this case was tortured?
Yes, I did.
What is that opinion?
My opinion is that it was tortured. The individual was seen striking at the dog with a good amount of force, and in a 45-second time frame, 17 times. It was definitely excessive and appeared to be cruel.
I pass the witness.
All right, defense.
Yes, okay, Ms. Miller, or is it Miss Miller?
Yes.
And you stated that the discipline methods don't depend on size, correct?
I mean, not necessarily. I would say that that type of discipline against a larger dog would be unacceptable.
Okay, and so you would agree with me that you have knowledge of the law, right, in this particular statute, and that she has been charged with torturing non-livestock.
Correct.
Okay, but you also deal with livestock cases as well.
I've worked with livestock, wildlife, exotics. Yes, ma'am.
In livestock, the definition, the torture definition under livestock and non-livestock is the exact same. You can't, the definition is to not cause unjustifiable pain or suffering, correct?
Correct, but there are different acceptable means for livestock and domestic animals. Unfortunately, domestic animals are protected more.
Well, so the statute itself does not distinguish in regards to torture between livestock and non-livestock. The definition of torture is causing an animal unjustifiable pain.
Your Honor, I would object
suffering.
because that's not the verbatim statement of the law.
That-
that she
All right, so
claims.
here's what I want to tell everybody. You all have entered into a plea bargain agreement. If questions are being asked to try this case, then you all should not have entered into a plea bargain agreement. And what I'm saying goes for both the state and the defense. Then you all shouldn't have entered into a plea bargain agreement. You all should have went to jury trial. If there is a foundation that somebody's trying to lay that this law may or may not be unconstitutional, that's not what the trial court hears. I don't hear whether a law is unconstitutional or not. You need to take that up to the appellate section and how the laws are written. My only job is to follow the law as written. And I want to remind both parties, I read the stipulations because I read the stipulations when y'all entered into the plea bargain agreement. I've seen the video. I've seen the video because y'all included in the stipulations. So I want everybody to understand, I remember what's in the stipulation. I remember what's in the video. So with that being said, go forth with your questions.
Thank you, Your Honor.
Yes.
So my point is though, that the definition is not different, correct? For livestock versus non-livestock.
They're just under different statutes, so I'm not sure what.
Okay, and so it's the same. So you would agree with me that there is, in your profession, you use this kind of personal decision on what is justifiable and unjustifiable, correct?
I do not, I use my expert opinion, not my personal. I don't include any of my bias. I looked at everything at an objective standpoint.
Okay, and you suggest that striking an animal 15 times, 15 to 17 times, potentially, is torture, correct?
With force, yes.
Okay, and this was a flaccid leash that you observed, correct?
It's a leash-like item, yes.
Okay, and so you would agree with me that you don't go down to the racetrack and arrest people when they beat those horses in the races with a hard crop.
So what is
15
acceptable
times.
for horses and horse racing is not the same as what's acceptable for domesticated animals.
Okay, but that is not in the law, correct? The law doesn't say it's different, justifiable for a livestock as it is. There's a different definition. There's no different definition for torture.
I'm not sure how trying to justify that for this case or what the point is.
The point is that our society routinely.
All right, so let me stop everybody there. There needs to be question and answer. So if you can answer the question, please answer the question. If you cannot answer the question, then you cannot answer the question.
I'll ask the question. Sorry.
No problem.
You agree with me though that you don't arrest people at the racetrack when they are beating their horses with a hard crop, correct?
If there's no evidence that cruelty existed, no.
And have you ever arrested any of them? Have you ever seen a case where they've been arrested and charged with torture?
No, ma'am.
Now, let's talk about, you say that this was, you wrote a report and you did, your report contains that there was no bodily injury found to the animal, correct?
That's correct.
All right, and that just in case the animal was feeling pain, that they administered some, I guess it would be like Tylenol type substance to the dog.
It was chlorpropane, as Tylenol is toxic to dogs.
I apologize. It would have been some type of pain medication, despite the fact that you even indicated in your report, it was unclear whether the dog was in pain or not.
That's correct.
So, you would agree with me that when you show up to get the dog, from the residence of Miss Miller, that, the dog is, in a very nice little crate. Correct? It's the pop-up crate?
It was contained in the restroom, not inside of the crate.
Okay, but, clean area?
The area was clean, yes.
Okay, pee pad was there?
Yes.
Toys?
I believe so. I can't recall.
And the dog's active and when you walk in?
Yes, correct.
And you would agree with me that in your report, and nor on the video camera, does it note any kind of concern with how the animal's walking?
I did not observe any abnormalities, no.
Okay, and the animal was happy to see you,
Yes.
allowed you to pick it up?
Yes, ma'am.
You didn't indicate in your report that the animal was running from you or afraid of you?
That's correct.
Okay. Now, in regards to your report, you also put that it may have been struck. You could not tell if the dog was actually struck.
I could tell it was struck. I could not tell if it was struck every time that she struck at it.
Okay, so there was on the 15 times that you claimed that she was holding the puppy or dog, that it was, the view was obstructed, correct?
Some of it was, yes.
Okay, and during those 15 times, you couldn't tell if it actually ever made contact with the dog.
There are times that where you could see the leash-like item, you could see it strike in the area where the dog was at, and you could hear it making physical contact with something. So, believe it.
You believed it, but you don't know because you couldn't see it in the video. You're just jumping to that conclusion.
Not necessarily, no.
Well, you can't tell if it hit you would agree that there was a crate, like a pop-up crate that was, that houses like a kennel that was blocking the view of the dog.
In some of it, yes.
Okay, in the 15 times that you broke it up into 15 versus two additional times for a total of 17, right?
I can't say that it was fully obstructed, for all 15.
Oh. I pass the witness.
Any further questions?
Not for this witness, Judge.
All right, thank you. You may be excused. State call your next witness.
State calls Reina Rubio, excuse me. That's Raena.
Hello.
Hi.
Hi, could you raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name.
My name is Reina Rubio, or Reina Gale, sorry.
All right, state, you may proceed.
Hello, how did you become familiar with Thanos? I had seen a video of, do you want me to state like the Facebook group and everything? Just answer what's being asked of you and we'll break everything. Okay, I was on Facebook and I had seen a video of Thanos getting struck again on his outside porch. And then that's how I came to know him. Okay, so you said on Facebook, where was this video posted? It was posted in the Doodles of San Antonio Facebook group. Are you a member of that group? Yes, ma'am. Why are you a member of that group? Just because I'm a dog groomer, so I get a lot of clients through that platform. When you saw the video, did you watch it? Yes, I did. What did you observe in that video? I observed.
Your Honor, I'm gonna object to this line of questioning and the relevance of this witness. We've already admitted the video. It's in the purview of the judge to review the video. She's no more qualified to review the video than the judge or the trier of fact.
All right, so what's your legal objection?
Is relevance.
Sustain.
Okay, Miss Rubio, did you ever come into contact with Miss Miller? No, the only form that we spoke through was her Ring door camera, but I never saw her like face to face. But you did communicate with her? Yes, that's correct. Why did you communicate with her? I wanted to see if I could, I guess, take Thanos from her, buy him from her. And she actually did agree to that. Did you offer her money for Thanos? Yes. How much did you offer her? It was 300 at first. And then we agreed to that. And then she had given me her number, saying that she was at work and that she would, she asked me to text her. And once she got home, she would text me a time to meet up for me to adopt Thanos. She said she was at work, so she would let me know when she got home. Do you recall the date that y'all communicated regarding the purchase of Thanos? I think it was January 18th or 13th. I'm not sure. I know it was the beginning of January though. So after y'all made this initial agreement, you stated you first offered $300, is that correct? Yes, that's correct. And you said that the price changed. Is that also correct? That is correct. What did the price change to? She said she had gotten Thanos for $1,000 and that he was an emotional support animal. And that he's updated on all his shots and everything. So she would take $750 minimum. And then so I said, let me see what I can do. And then so we agreed to that. But she had also stated that she had him posted on Craigslist for a while for $1,000. And did you have the $1,000 to pay for the dog? I did not. So what did you do? I had posted the video to my personal Facebook.
in hopes to raise money in order to get Thanos out of that home.
Did Miss Miller
object to relevance?
Overruled.
Did Miss Miller ever ask you to take the post down?
Yes, she did. She said she would give me Thanos as long as if I took the post down.
Did you take the post down?
Once I did raise enough money, I did take it down. And then, you know, it had gotten a lot of, I guess, a lot of people noticed it. And so a lot of other people were posting that video. And she would just wanted me to tell everyone to take it down.
And did you tell others to take the video down?
I didn't know anyone. You know, there was a lot of random people posting it.
But did you know anybody that shared it personally?
Yes, not personally, but I know her. I work with her through a rescue. So, yes, I do. Just one.
So, okay, so my question is, of the people that you were aware of or had prior experience with, did you ask them to take posts down on Miss Miller's request?
Yes, I did.
At any point with your conversations with Miss Miller, did she ask you to stop contacting her?
Yes.
When did she ask you to do that?
It was after Thanos was picked up by the animal care services. Or actually it was before. She knew that animal care services was going to go pick up the
Objection,
dog.
Your Honor.
And she,
Objection,
Yes.
that she has no way of knowing what
What's your legal objection?
that she has no personal knowledge of what someone else believes.
All right, and so your legal objection?
Uh,
Is it hearsay?
Hearsay,
Sustain.
sorry.
No problem. It happens.
Did you continue contacting Miss Miller after she asked you to stop?
no, but she had contacted me.
Did you continue posting about her and or Thanos after she asked you to cease communication?
No.
At any point, did Miss Miller inform you that she was being threatened as a result of this video?
Yes.
What did you tell her in response to that?
I told her she could reach out to authorities if she really fears for her life, but I mean, it's honestly out of my control.
At any point, did you have malicious intent toward Miss Miller or her family?
No.
Did you wish ill will upon Miss Miller or her family?
No.
Did you agree with those that were threatening Miss Miller?
No.
So you thought it was unacceptable?
Yes.
At any point with your conversations with Miss Miller, did she ask you not to involve the police?
Yes. She was, whenever we first spoke through the Ring camera, she initially said that the police had been there, checked on Thanos, and that he's okay. And I said, well, you know, if I can't see that he's doing well, and you know, that she would, if I can't see that he's doing well, then you know, I would have to call the police just to make sure that he's okay from that video I saw. And she said that she would sell me Thanos. She was very adamant about me not calling the police.
Pass the witness, Your Honor.
All right, defense.
Yes, so you're telling that your testimony today is that you post a video to make money off of the video of a animal that you claim was being harmed?
Not claiming it. There was video proof, and it was to raise money to adopt Thanos since she raised the price.
And so, how much money did you make off this video?
I didn't take any money actually, since she went ahead and gave up on contacting me for Thanos. I didn't collect any, but there were people willing to donate.
So you just said your testimony was that you had raised enough money.
There were people willing to give me money if I had Thanos, which I never even saw him. So I did not attain any money.
And you claim that the reason that you took down the video was because Miss Miller asked you to, correct?
Yes.
So you were aware that the video that you posted, that people were saying stuff so heinously as she needs to be gang raped.
I was not aware of that comment on my post.
Or that she needed to be killed.
Yeah, I was not aware of that being commented on my post, although I can't really control what other people say or do. Unfortunately, she decided to do this heinous act on her patio in public, and there's precautions for that, there's consequences for that.
And the point is though, is that you were aware that these threats were being made to her and you didn't take it down or try to diminish it at that point. It wasn't until you claimed you spoke to her and she asked you for her self-protection to take it down.
At the time, the first time, it was not for self-protection. She said, take it down. And this was before I was aware people were threatening her. She told me first to take it down because she didn't want it to get around because of her school and her job. She didn't want them to see it, and she would give me Thanos. So that's why I took it down.
I pass the witness, Your Honor.
Any other questions?
No for this witness, Judge.
All right, thank you.
Thank you so
Call your
much.
next witness.
State calls Ethan Park.
Raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Officer Park,
All right, state, you may proceed.
Thank you, Judge. Officer Park, how are you familiar with SAPD 250117779?
Recently familiar, ma'am, no.
Yeah, what case is that?
That would be the case that we are working on right now, the animal cruelty case.
What was your role in that case?
I simply provided with transport,
Okay, and that was transport when?
on the day of the incident.
Do you recall who you transported that day?
Yes, ma'am, it was Miss Savannah Miller.
Is Miss Havana Miller recorded?
Yes, ma'am.
Okay. So in that case, you provided transport. Are your you were in your patrol unit, correct?
Yes, ma'am.
Is your patrol unit equipped with video capabilities?
Yes, ma'am.
To your knowledge, was it operational?
Yes, ma'am.
I hand you what will be marked as exhibit 2. This is the back seat. I hand you what's been marked as State's Exhibit 2. Do you recognize this?
Yes, sir.
What do you recognize it as?
Should be my dash cam.
To your
My
your-
patrol car.
to your patrol unit, and this is the events of January 18th, 2025.
Yes, ma'am.
Other than to comply with the rules of evidence, has it been altered or amended in any way?
No, ma'am.
At this time, Judge State would offer this to defense for objection.
Your Honor, I don't object.
At this time, Judge,
And what is exhibit number is that?
number 2, Judge.
All right, state's exhibit number 2 is admitted without objection.
Officer Park, when you transport people, do they make conversation with you?
Most times, no.
Most times, no.
Most times, no. No, you're.
Your Honor, before that's played, can I take this witness on board ire to make sure that Miranda is? I was not aware that they were introducing videos today, but I just need to make sure there's no Miranda objection.
Well,
that would
we all
apply.
have already admitted it into the evidence, so it's in evidence.
But it hasn't been viewed, and I would like to ask the court's indulgence to at least take him on board ire to make sure that Miranda was read. and
Have
we
you
don't-
seen the video?
If I've seen, I didn't view it today, and I don't know, I don't believe Miranda.
And it has been, Miranda was issued by another officer that arrested her on the scene. He was merely the transporting officer to the magistrate's.
If the state is representing that she's been Mirandized at this point, then I would draw my objection, but they're representing that since I was not aware we were doing videos today, I didn't go view any videos to make sure that what they're admitting is post Miranda.
All right, so you're withdrawing your objection?
If the state, are you saying that this is post Miranda?
Yes, this is
Okay.
post Miranda.
Okay, then Your Honor, I would draw my objection if it's post
All
Miranda.
right, state, you may proceed.
Thank you, Judge.
All right, could you pause for a minute? Could you pause for 1 minute?
Yes, Judge.
All right, everyone else, you need to be back here at 1:30. All right, you can continue.
Officer, what song was playing in your patrol unit on January 18th?
That was a hip hop song. It's called Gang Gang by the rapper Moneybagg Yo.
So with me, I'm sorry. I didn't
No,
understand.
no, you're okay. It's called Gang Gang. Is the song title. So
It's just hard to hear. Okay, I realize that.
I passed the witness, Your Honor. No further questions.
All right, thank you.
thank you.
Spence, I'm sorry, State, do you have any other witnesses?
No, Your Honor, that was blacklisted.
Spence, any witnesses?
Your Honor, at this time, I call Havana Miller.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. State your name for the record, please.
Havana Dejanay Miller.
All right, defense, you may proceed.
I asked you if there was anything that you wanted to say to the court before you were sentenced, and you said that what was your response to that? There is, that I do want to say something. Okay, and this is your opportunity to speak to the judge. What would you like to say?
So, Your Honor, I would like to say that I completely understand that my actions were not okay. I did allow a moment of overwhelmed, being, frustrated to take over me. I do take this whole thing as a learning lesson, and I'm sorry that the puppy had to be part of this learning lesson, but I have learned to control myself, to have more patience. I'm sorry to everyone involved, including the puppy, even the people that have been against me in this, social media, the people that came in today. I'm sorry that they had to see that side of me, because I know that that's not who I am. And I'm sorry to my mom. I'm sorry to my family, my nieces and nephews that were threatened due to this. And I know that that's not something that I would ever do again. I'm not a troublemaker. I go to school, I go to work, and I spend time with my family. I'm not a danger to society. And again, I allowed a moment of frustration to take over me. And I'm sorry that I had to learn these things this way. It shouldn't have taken this. And I'm sorry that it did. And again, I'm sorry that the dog had to be part of this learning lesson for me.
Okay, and I'd also like to ask, you are employed right now, correct?
I am.
How many hours a week do you work?
Right now, I'm working 50 hours a week.
And in addition to being employed, are you going to school?
Yes, I am.
And what are you going to school for?
I just don't feel comfortable saying that,
Oh.
only because of social media.
Okay.
But I would tell the judge, I could write it down.
No, it's okay. And in regards to that, are you currently taking classes?
I am.
Are you, the state has asked for a jail sanction. You're aware of that? And, in regards to that jail sanction, is there a reason why you do not think that that would be appropriate here? Okay, and why is that?
Because like I said, I have learned this would be a major setback for me. I get all A's, I get A+, I have a 4.0 GPA. It would set me back on something that I know that I'm not gonna cause trouble. I'm not gonna cause trouble to anyone. And it would also set me back with my job. I need my job to pay for my school. So it would just set me back, and I'm not a danger to anyone.
And at this time, I'm gonna pass the witness, Shauna.
I have no questions for Ms. Miller, Judge.
I do.
Yes.
So, do you currently own any pets.
No, ma'am.
So tell me, what was going on in your life at that time that it came to this point?
At that time, and still to this day, I have been grieving. I'm sorry. I'm grieving my dad.
Mhm.
It's hard for me to talk about it and hold it in a lot. And again, that doesn't give me a reason to do that to the puppy.
Mhm.
But I did allow it to take over me. I had been up all night, but trying to potty training, and I had got up again early that morning, and it just at that time, that's what was really, really heavy on my mind. Of course, there's other things, and but that's the main thing.
So did your father pass before or after you purchased this animal?
Before.
All right, so he passed before and you decide to take on a pet in your life. So I don't understand how you get to the point where you're hitting a puppy
Mhm.
with a belt or a strap. I don't understand how you go from that to this, and it's a puppy.
Right.
And when puppies use the restroom inside the house, you know whose fault that is?
It's mine, but that was not the case.
Oh, so then why were you being frustrated with?
I was frustrated that morning because I had taken him out to use the restroom and it was really cold. Again, this is not his fault. It's mine. But he was doing that thing that dogs do, like when you're trying to get them, they're not ready to go inside, and he kept running away every time I would go towards him, running away and playing around. And I was personally not in a playing mood. And I took him upstairs. That's not when that happened. But then I was trying to leash train him, getting used to his leash. And I saw online that to leash train him, you can put the harness on them, put the leash on the door, so that way they can get used to it. Of course, giving them room to still walk, but right there. And I guess he had got frustrated with that, and he did do that, and that was what caused me to do that. Again, it's not a justifiable reason.
So why did you have him, how long did you have him
It was
on the
only-
leash on the door?
It was only about 30 minutes at that time.
And so you didn't notice that he was biting through the leash?
No, ma'am, because I was inside and he was on the balcony.
All right, so outside on the balcony, biting through his leash
His harness, yes, ma'am.
and his harness. I still don't understand how you go from that to striking a puppy.
Just allow.
So I'm trying to understand how you get to that point. First, you've taken on a puppy. Your father, as you stated, had already passed, but you decided to take this puppy on into your home.
Mhm.
And then we get to a point where you're striking a puppy on the balcony. I'm trying to figure out how you get to that point. Because puppies are going to do what puppies do. And when puppies come to you, if they're puppies, right? Depending how soon they were taken away from their mothers, usually they come to you and they're not trained. So you took on a puppy that wasn't trained. I still don't understand how you get to the puppy bites through the leash, and you're saying it took 30 minutes for him to bite through the leash. So you had the puppy outside on the balcony in the cold, because you said it was cold outside, strapped by a leash, and he bites through the leash. So I'm trying to understand. Because I will tell everybody, I'm inclined to follow the agreement that you've reached. Now I'm trying to consider, because the state is asking for jail time. So I'm trying to weigh things here, because my intention, if I'm placing somebody on probation, I'm not trying to ruin their life where they can't go to school or they lose their job. But rehabilitation sometimes is just not rehabilitation. Sometimes it's punishment thrown in, right? And it appears that your punishment may be, the fact that you're on probation. And I have to make a consideration whether I give you deferred or give you a conviction. All right, so that's what I'm trying to understand. How did you get to that point? Because you're saying it's cold outside, but you have a puppy on the balcony. And how big was this puppy? Is it one of those puppies that sit in your hand?
He wasn't that small, but like they said, he was about 3 pounds.
All right, so how small?
He was like
All right, so you have a puppy who's sitting on the balcony in the cold, strapped to a door or whatever, because you say you're trying to teach him how to be on a leash.
Again, I got that from online. It wasn't punishment. I was genuinely.
Oh, no,
just
I
trying to
understand
teach him.
I understand you're saying you got that online, but I'm trying to get to the point of you place him on the balcony. He's been running outside playing around. You don't have time to play. You got other things on your mind. You just want that puppy. Do your business for the love of all that's holy. And I'm taking you inside. And I don't know, maybe puppy's yapping around in the house. And then you're like, you know what? Go out on the balcony, learn to be on a leash.
So outside on the balcony, I did have his crate with blankets. Whenever I would go out there, he felt warm. He wasn't shivering or anything. But to answer your question, Your Honor, getting to that point, I was just felt overstimulated. I felt frustrated, and I just, at that point, I just let my emotions get the best of me at that point. I do feel that from January to now, I have changed. I'm not saying I'm a completely new person just yet, but I have learned to control my emotions better. Don't just get angry so quickly, or, actually speak about what's going on in my mind, so that way I don't hold it in, and things like that happen where I lash out, and I allowed that to happen.
All right, and what is this about the witnesses testifying that they wanted to buy the dog from you and then you're increasing the price? What's that about?
So that was because when she came to my door on the Ring doorbell, I did say, as she said, that 2 cops had already came and checked on the dog and he was completely fine. She mentioned, well, I don't feel comfortable. I'm not going to be able to sleep tonight if you don't give me the dog. And I'm saying, basically, that's my dog. I don't have to give you the dog just because you want my dog. And so long story short, I was, frightened by the fact that she was threatening with the police. So I said, okay, well, if you don't get police involved, because I knew she had a video and she had it posted on her Facebook. At the time, I didn't know it was her Facebook. She just told me that she saw it on this neighborhood website or neighborhood app. And she told me that she saw the video online. I was asking, well, how did you even find me? And she said that she looked at the balconies and she did see the dog out there on the balcony.
Let's get to the money, the exchanging of money or not exchanging of money.
The money
The
part.
witness testified, and you can correct me if I'm wrong, right? But I recall the witness testifying that you all had maybe agreed on a price. Then after you agreed on the price, then you upped the price. And then
Yes.
she said she had to post some video in order to raise funds so that she could purchase the dog. So let's
Yes.
talk about that.
Okay, that did happen. And she did offer me 300 because, like I said, I was frightened that the police were going to come. So I was willing at that point to do that. But then I thought about it and I said, I didn't want to just give up my dog. I did love my dog. And
So then why did you increase the price?
because I felt that if I had paid $1,000 just to get him, I had done the shots and everything for him. He was up to date on everything. I had bought him, all the supplies that he needed at home, food, things like that. So I just felt if she really wanted the dog, then she could at least pay the minimum price of him, which was $1,000 to get him.
All right, and did you talk to family members about what was going on in regards to this case and what was going on in your life?
Yes, ma'am.
Did you tell them, hey, I need some help? Can anybody take the dog?
No, I did not. I don't have people that I believe would have been willing to do that.
Okay. All right, any other questions?
I have a couple of follow-up questions.
Sure.
Okay, your dad, you say passed away after you got the dog? Before, how long before?
2 years.
2 years, okay.
Not even. Not even like almost 2 years at that time.
Do you know what the date was that he passed away?
He passed away June 17th of 2023. No,
Of
yeah,
2023?
June 17th of 2023. Sorry, it was because he was brain dead and then they donated his parts, so he wasn't actually dead.
Okay, and so, did you adopt the dog or get the dog as a way to cope with any kind of mental health issues?
I did, yes.
And during this time period, were you getting much sleep when you had the dog?
I wasn't.
How long did you have the dog?
About a month or 2 months.
Okay, and so you were a month or two with no sleep, correct? At this time. Do you think that your lack of sleep and your mental health situation put you in a position to not use better judgment?
Yes, ma'am.
Okay. At this time, Your Honor, I pass the witness.
All right, so I can tell you your versions of events, and I understand what you're saying, and maybe you just skipped over a little bit. In the PSI, your versions of events are, I was tired and let my emotions get the best of me. I was at home at the apartment. I had just been up early as I had a late night. I was trying to potty train a pet that was involved in this case. I saw the dog's harness. I got them. I had taken them out and they didn't go. They had an accident. I got upset as the new harness was chewed up. All right. Is there any other questions? Any other witnesses?
I don't have any other questions.
All right. I'll have you all come back at 1:30 and I'll make my decision at that time.
Okay.
All right. Thank
And,
you.
Your Honor, I would like to, at least have an opportunity to make a close.
No, you all will have an
Okay,
opportunity.
thank you.
Thank you. All right, we're back on the record in 2025 CR 001454, State versus Dejanay Miller Havana. Can I have parties re-announced, please?
Megan Galloway for the state.
Jody Sawyer's the defense.
All right, is there any other evidence to be presented by either side?
No, by the state.
And not by the defense.
All right, court will hear brief argument.
Thank you. Your Honor, first off,
Yes.
Judge, I'll reserve, I need to look at.
All right. Go for it.
first off, we're not condoning the behavior, but I think we need to keep it in perspective. I understand that a video caused sensational backlash, but the reality is there's no visible injuries to the dog. The dog was not physically maimed in any way. And when you think about that, in our justice system, we don't really honor an eye for an eye. But in this case, probably the more appropriate punishment, in addition to having been humiliated socially. And that is a huge thing. This has been a very difficult situation for her to live through, being threatened and all of that. But, it's a flaccid leash. And when I went to high school, they did corporate punishment. I don't see, if this is so egregious, then the punishment really should match the crime and have her ordered to be struck 17 times with the same leash that she struck the dog with. That's more appropriate. But I disagree with the fact that the state is asking for a jail sanction here. This young lady has no prior criminal history. She got straight A's. She is employed. And again, like I said, neither she nor I are condoning her behavior. She's taking responsibility for it, but it needs to be kept in perspective. In regards to her being a first-time offender, no rehabilitation or mental health has been given to her at this stage. So I believe that would be appropriate. I am asking the court to consider the fact that torture, while the court has found that it is sufficiently met, the elements sufficiently met here, there is no lesser included, and it doesn't even require bodily injury. So on the scale of this particular type of offense and the things that we see in our practice, you and I have, I think, been doing this for over 20 years. We have seen egregious cases that fall on the scale that are very offensive. And while this is not something that we condone, I do not think it falls on the extreme of this type of offense, even if the court believes the elements were met. I am asking the court to grant her deferred adjudication, give her the ability to prove herself. I believe that with no prior criminal history, we shouldn't jump into any kind of jail time or prison time for that matter. And I'm asking that the court order anger management and all the things that the pre-sentence investigation we're talking about, with the exception of a jail sanction. I also want to point out that in the pre-sentence investigation, she stated that the way that she was raised was discipline was love. It was synonymous, that if you weren't disciplined, you weren't loved. And I'm not saying that, again, no one's trying to excuse the behavior, but I think that's an educational thing. She was treated the same way growing up, and it's something that we do need as a society address. And some of maybe the way we see things, and maybe even the way that society sees things and does things openly, and does it and is condoning openly to animals. Like, for instance, shock collars that are sold. There's things that our society accepts, and while I'm not saying that what she did is acceptable, I just don't think it rises to the level of being as egregious as it may have appear on the video, based off of the actual result. And I believe this is a result-oriented crime. And so we're asking the court to give community deferred adjudication. Okay. Thank you, Your Honor.
All right, stay.
Your Honor, state is asking for community supervision and with the 180-day jail sanction based on the fact this is an egregious act. Thanos was a 3-month-old puppy that was defenseless, and although he's not verbal, cannot speak with words, that video speaks for itself. He was yelping in pain as she struck him what appeared to be 17 times while muzzling his mouth, presumably to keep him from making sound. Miss Miller testified here today that it was cold outside and he initially was outside for leash training. When she came into the presence of officers, she told them he was outside because he had soiled in his kennel. She told you today in court that he was out there with blankets, but as you can see in the videos, that's not the case. She initially lied to officers during the welfare check. She said nothing was wrong and that others had dogs in the unit, knowing full well that she had just struck Thanos and that the officers were aware of the fact that she had done that because they saw the video prior to making contact with her. Her acts were callous. He was muzzled and she struck him. He got away and she continued to hit him. Defense would have the court believe that not all 17 blows were to Thanos, and she mentioned the pop-up kennel. However, in the video, you can see that pop-up temporary kennel wasn't moving as if she was hitting that kennel instead of the dog. She then agreed to sell the dog to Miss Rubio. First, the price was $300, then it went up and up again once she realized that it would be an inconvenience for her to not break even. And I would assert inconvenience would be a theme here today. Miss Miller states that she cannot do a jail sanction because it would be an inconvenience to work. It would be an inconvenience to her life, but that inconvenience should have been thought of prior to even getting a dog for ownership. She testified that unfortunately her father passed away in 2023, but this incident would occur a year and 6 months later approximately. Pet ownership is very important. Judge, we need to afford animals that cannot speak for themselves and all things that can't speak for themselves great protection. And so we would ask that you do community supervision, even in transport with Officer Park. She was making light of the situation, stating she would remember that song for the rest of her life. But I would urge this court to show Miss Miller that she shouldn't remember the song that was playing during transport, but rather she should remember the cries of Thanos while she was beating him 17 times. Because of this, Judge, we would ask that you consider the totality of the evidence presented to you and sentence her to community supervision for 10 years, as well as allowing no pets, anger management, the pause course, and 108 days of jail.
All right. So this is what I'm going to tell you. When I have cases before me, I look at each case individually, right? Because somebody will come before me, and I've had people argue before me. Oh, there's somebody who had an aggravated assault with a deadly weapon where they shot somebody, they got probation, didn't get jail time. So I always try to remind people that each case is different. That's why I look at cases individually. I don't try to figure out, oh, this is what happened in this case, or this is what happened in this case. I just have to deal with the facts that are before me, right? And I understand everything that your attorney said. I understand that you don't have any criminal history. I'm going to give you a choice. Sometimes I can give people choices, sometimes I can't. But these are your only choices. And I'm going to give you a chance to discuss it with your attorney before you decide. All right? So here's your choice. One, I will either give you deferred adjudication, and I will give you deferred adjudication. I don't think 10 years deferred. I'll give you 8 years deferred adjudication. Or with that deferred adjudication, you're going to do some jail time. Or you will have a conviction and I won't give you any jail time, because sometimes, well, not sometimes, really all of the time, cases are about rehabilitation, but there's a form of punishment in it. So your only choices are, I'll give you deferred adjudication, but you'll do some jail time as a condition, or either you'll have a conviction and you won't have any jail time as a condition. I'll give you a chance to discuss that with your attorney.
Thank you.
All right, court is calling 2025 CR 009749, State versus Cullen Spencer O'Neill. Can I have parties annexed?
Lynn Brown for the state.
Brian Kimbrough for Mr. O'Neill.
All right, and are you Mr. O'Neill?
Yes, ma'am.
All right, according to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposed to your applications. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Your Honor.
Any objections to the PSI report?
No, Judge.
No, Judge.
All right, state, you're opposed. Do you have any witnesses?
No witnesses, Judge.
Defense, any witnesses?
Yes, we have some witnesses. Your Honor.
All right, call your first witness.
Before I do, Your Honor, I have some letters that I wanted to present the court on his behalf, and I believe, and I did give a copy to the state, and I believe they were opposed to my doing so. So I wanted to give them an opportunity to speak to that.
All right, any objections to the court reviewing the letters?
Yes, Judge, I'm gonna oppose their hearsay. I can't cross-examine the witnesses on those statements, and I don't believe they're sworn statements either, so I'm gonna object to them.
Well, Your Honor, I've produced, these have nothing to do with the incident. They're only about the character and the information about the defendant. I think it's part of the court's duty.
Great. So with regards to whether they're hearsay or not, the court needs to review it to see if it is hearsay. And then if the court determines it is hearsay, then the court can always disregard. All right, with regards to the state's objections to the court reviewing the letters that have been tendered by the defense, the court understands your objections. The court is going to overrule those objections. The court will take these into consideration in sentencing.
Would you like to have a copy so they can review them?
Oh, I've reviewed it. Yes,
Okay.
I read very fast.
Very fast. Thank you.
All right, call your first witness.
Your Honor, I would first call Tammy O'Neill.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record.
Tammy Hollis O'Neill.
All right, counsel, you may proceed.
Thank you, Your Honor. And what is your relationship with Cullen?
Yes, I'm his mother.
And could you tell me a little bit, was Cullen raised in San Antonio?
He was raised in
Okay.
San Antonio, born in Japan, but came here shortly after that because his late father was in the military.
And how long was his father in the military?
24 years,
What branch was he in?
Air Force.
Are you also in the military?
No, sir, I'm not. I work as a civil servant, but not now because I'm furloughed.
Because the government is
Yes,
shut
that is
currently
correct.
shut down.
That is correct.
You're the Air Force?
I do work for the Department of Defense. That's correct. Air Force. Yes, at the Air Force Civil Engineers Center.
So Cullen's father passed away 7 years ago, correct?
Yes, sir.
And
2018.
how did that, from your perspective, and was Cullen living with you at the time?
Yes, sir, he was.
And how did this affect him? The death of his father?
Hugely. It affected all of the kids, right? My daughter as well, but I think it struck Cullen much harder, right? Because of that father figure that he had in his life. And also that father figure to hold him accountable.
And how many siblings and other members of the family did he grow up with?
Yes, he has a younger sister, who's not here to testify today, ma'am. One of the letters was from her. She's full-time in college and couldn't come. And then he has a stepsister as well.
And can you describe his upbringing, his childhood? Was it normal? Was it good?
Yes, sir. It was good. I would say it was good. He got everything he wanted, you know what I mean? One of those. And I did the best to raise him, you know, with my husband and then as a single mom after my husband passed away.
Did Cullen go to school?
He did. He graduated. He's got a diploma.
He's got a diploma. He had to get a GED, right?
Yes, he did.
Yes.
He
but
did.
He did.
He struggled a lot in school with ADHD and also yes, so he has struggled with that throughout his life since he's been little, right? Hard to concentrate, anxiety, right?
And has he been employed, generally speaking, since he got out of high school?
Yes, sir. He has. He has.
Has he always sought employment?
Yes.
And to your knowledge, has Cullen ever been convicted of anything, any crimes in his
No,
life?
sir. No, sir. This is so outside of his character. And I have never witnessed this type of behavior in him, which is why this is so shocking. I've had so many conversations with him and I think he regrets what happened, right? I feel like from his personality, this is just not something he typically would have done. And I feel like that it was a mistake. He just made a poor decision, a very poor decision.
And he's always lived at home, correct?
Yes, sir.
And so you've gotten to know his friends.
Yes, absolutely.
Okay. And would you say, based on your knowledge and your observation, are his friendships appropriate age-wise?
Yes, sir. I've never seen anyone under legal age at my house. That's another thing I think that my daughter wrote in her letter, that even when I'm not there, she didn't witness that either as well. His relationships have always been with people of age, which is why this incident was so outside of his normal character.
And has he had friendships that were long-standing? In other words, friends that he's had for many years?
Oh, yes, yes. He has friends that he went to kindergarten with, right? And one is here today, actually, so.
Now, you know that we're here to ask the judge to place Cullen on community supervision
Yes,
for
sir.
adjudication.
Yes.
You think that he could succeed on community supervision?
Yes, sir, I do. I do. I very much do. I think that he needs that discipline, right, of being able to check in continually. He's been on an ankle monitor for the last year and a half and has done that very successfully, right, to be able to check in and be accountable to that. I think that he can give back to society by working and doing other things while he was on probation versus if he was incarcerated.
And that's fine. Pass the witness.
All right, any questions?
No questions, Judge.
All right, thank you.
Thank you. I appreciate your consideration. Thank you.
And I would call, yes, I would call Deborah Higgins. Deborah Higgins.
All right, can you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
And I treat him like a son of mine. So this is totally out of character.
What is your son's name?
Daniel.
Yes, I would call Deborah Higgins. Deborah Higgins.
All right, can you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Deborah Higgins.
All right, counsel, you may proceed.
Thank you. And Ms. Higgins, you go by DJ, is that correct?
Correct.
Okay. What's your relationship with Cullen? How long have you known him?
I'm a family friend of approximately 14 years.
Do you remember how you first met the family?
I worked with Cullen's mom.
Was that in the Department of Defense
Yes.
area?
Yes.
Are you still working there?
No, sir, I retired July 25th this year.
And in the course of working with his mother, did you get to know Cullen a little bit?
Yes, I would go to their house for holidays and dinners and cookouts and whatnot.
What did you observe about Cullen during your period of knowing him?
He's a good kid. You know, he was raised well. I watched how him and his sister were raised. They were raised well. They did well.
Did you have occasion to see him with other young people?
I met one or two of his friends when we were all at the house. They're good kids.
And did you ever hear about anything that he might have done other than this incident that raised concerns for you?
No.
And you also work in pet safety or something?
Animal rescue.
Animal rescue.
Yes.
So you observed what happened today and you
Yes.
familiar with it.
Yes.
So you do not condone bad behavior?
Absolutely not.
Okay.
Right is right and wrong is wrong.
You're hardcore on that.
Very.
Okay. And you know that what Cullen did was wrong.
Yes.
In spite of that, do you think that he could succeed on community supervision if the judge would give him that?
With structure, accountability and discipline and having to stay focused on that thing, yes, I do. I think he would do very well with that.
And do you think that would be a better outcome than sending him to prison?
I do.
Why is that?
There's prison structure and there's, I don't know the right legal term, but probation structure. And I think him being employed, being forced to do the right thing every single day in a more open environment would be more beneficial to him to grow as a young man.
Pass the witness.
Any questions?
No.
All right, thank you.
Thank you.
Call your next witness.
Yes. I would call Melissa Daly.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
I'm Melissa Daly.
All right, just keep your voice up so the court reporter can hear. Defense, you may proceed.
Thank you, Your Honor. Ms. Daly, you're acquainted with Cullen O'Neill, correct? How did you know Cullen O'Neill?
I've known Colin since he met my son practically in kindergarten. And all of them, all the groups of boys always played in the neighborhood. So I watched basically Colin grow up since kindergarten.
Okay.
And he's always showed the utmost respect and yes, ma'am. And when I had groceries, he'd be the first to come help me take them out of the car. I had him spend the night several times. And I treated him like a son of mine. So this is totally out of character.
What is your son's name?
Daniel.
Daniel, and he is a friend and grew up with Cullen, correct?
Yes, sir.
Is Daniel here?
Yeah.
Daniel, okay. Now, would you, if you had had any issues with Cullen as far as his influence, would you have allowed Daniel to spend time with Cullen?
I hadn't had any issues with Colin.
Right,
so,
but if you had.
Oh, of course I would. But I have not seen, Colin's always presented great character and integrity. And I thought when he was raised with his father hunting and having all the things that every boy would dream to have with a dad do. And since his dad passed, it was very heartbreaking. But he had a group of friends that supported him. So he wasn't like a loner child. He had lots of friends. And that helped him get through that horrible situation during his prime time in childhood.
And do you think that that he would be a good candidate for probation, community supervision?
Yes, I do.
You think he could succeed on that?
I absolutely do think he succeeds. He's has high integrity, and this is just outside his character. This incident.
Thanks. Absolutely.
Any questions?
No.
All right, thank you so much. Call your next witness.
I'm going to call Cullen, Your Honor. Cullen O'Neill.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help
Yes,
you
ma'am.
God? All right, you can lower your hand, state your name for the record.
Cullen O'Neill.
All right, defense, you may proceed.
Thank you. Cullen, you know why we're here?
Yes, I do. I made an egregious mistake one night. I had no sympathy for the situation I was in due to being under the influence of drugs and alcohol. And I made an honest young man mistake with my emotions and what I was trying to do. I made a horrible mistake. It's been haunting me. And I mean, I've had to deal with it for a year and a half that I've realized it and sat with it. And people have made fun of me. I've gone through it, but it's something that I know that it's not over because I made a mistake and I'm willing to take that on the chin. You know what I mean? You talk about football and LSU. I'm leaving it all on the field. You know what I mean? With what I'm trying to do to prove that I need a plea, but I made a mistake.
Okay. Now, the evening this happened, you had been using drugs, correct?
Yes, sir.
And you'd been drinking.
Yes, sir.
So you have an issue with drinking and with drugs.
Yes.
And you're willing to deal with that.
100%.
Okay.
To get better.
To get better. Do you have an attraction to younger women?
No, ma'am. I mean, no, sir. I've never once ever in my life. I think it was just the influence I was in, the situation of not sleeping, being tired from work, just and my emotions, my feelings as a young man just overcame me. And I know that's horrible and I made a mistake for that.
Okay. Now, you did complete your GED, correct?
Yes, sir, I did.
Okay. And do you have plans and things that you want to achieve in your life?
Yes. So I was a month away from finishing college when this all happened. And I had been held back for a year and a half to even finish college. But what I was doing in college was being a gunsmith. I get with my situation now, I might need to find a different line of work. And what I've been doing as an iron worker and doing stuff outside and building buildings like Chick-fil-A's, Walmart's, and Chase Banks and stuff around the community the best I can.
Now, you were employed with an iron, what kind of a company was it? An iron?
It was an iron company. It was Hill Country Steel. We do all the main steel around all of San Antonio, Austin, and Dallas. We do every Walmart, every Chick-fil-A, every Chase Bank, every car wash. We provide the steel.
Well, did you start working with them when you were in high school?
Yes, right out of high school. One of the letters I gave was from the employer that I've known since right out of high school, and he helped me a lot. And he knew about my situation through house arrest and getting my job back.
Now, you're not currently working for him, right?
No, I stopped working for him because I wanted to deal with this and didn't want to interrupt their company for my mistakes.
And are you hoping to be able to get work again?
Yes, I actually have a job interview on Thursday for another steel company that was smaller that we used to provide steel with. So that's something I'm really looking forward to start doing and working.
Tell the judge why you think you could succeed on probation.
I did track, football, and baseball all throughout high school. And I work harder than most grown men that I know. And I know I messed up. And I don't want to do prison because that's just not something I know I will succeed in, unfortunately. But I know that doing the plea and being on a schedule, checking in and doing things like that will really help me a lot. Get my life back on track. I'm young. I made a horrible, horrible mistake for my age. And I know that I want to be able to recover from it and not be stuck.
Now, when this happened, understanding the situation, you do admit that you were told that the girl was 15.
Yes,
correct?
Yes,
and you also admit that when you were going to see her, it was because you were intending to have sex with her, right?
Yes, I admit to that. You know what I mean? I admit to the court to take my honesty because I made a mistake.
Yeah. But that's not something you have ever done.
Never thought about it, never once been around it. And I have a little sister. How could I do that to her?
Okay.
You know, like that's something that I really think about a lot and being a better image for her, especially with the situation I'm in. I want to get out of this and be better for her. And she was one of the main people that wrote a letter.
Okay. Pass the witness.
State.
Yes, ma'am.
You talked to probation prior to this hearing, correct? The pre-sentencing report?
Yes, ma'am.
And when they asked you about the offense, you minimized it, correct?
I was nervous to what I said. I was very nervous on what needed to be said, and I wasn't sure what to say. I've never been in a situation like this, and I've never had the thoughts that I had.
But when you spoke to probation, you did minimize what you did in this offense, correct?
I wouldn't say minimize. I told my side the best that I felt that I could, but I did make mistakes. I did say things I wasn't supposed to, and we're here in this situation because of my mistakes.
Right. And the officer didn't force you or coerce you into this situation.
I mean, it was a sting operation.
Correct, but you willingly agreed to meet this person. They didn't force you to meet them,
Yes,
correct?
after like maybe 30, 45 minutes of time had passed since they had started talking to me, yes.
And you described in great detail and graphic language exactly what sex acts you wanted to perform on this 15-year-old. Is that correct?
Yes.
Pass the witness, Judge.
Any other questions?
No, Your
All right, any other witnesses?
no, Your Honor.
All right, court will hear brief argument. State.
Judge, I'll let defense go first.
Your Honor, Cullen O'Neill, in my opinion, is a perfect candidate for probation. He checks off the boxes, so to speak. He's 22 years old.
Okay, and not to interrupt your argument, counsel, but this.
Well,
no. This is what I wanted to address, but nobody addressed it. I don't know if anybody wants to address it. And it has to do with the cocaine that's mentioned in the PSI. And I don't know if you want to address part of that with your.
Yeah, I mean, I could ask him.
Okay.
If I could recall.
And I'm sorry about that. Yes, you could recall it.
Sure. You had cocaine that night, correct?
Yes, it was for myself, yes.
And you were using cocaine.
Yes, I was.
And you were, as you earlier testified, you were using alcohol too.
Yes.
And you had and did this problem develop like years before?
It mainly developed a year or so before of just working hard and just trying to stay up and just trying to deal with college and deal with a full-time job. I didn't know how to overcome myself or talk to and that's just what led me down the rabbit hole right there, and I just messed up.
And you understand that when you got to the point what happened that night, you were showing you had an alcohol and drug problem.
Yes, I definitely did.
And you have it now. Correct?
I wouldn't say now. I have definitely resorted to staying off, being a lot better person just due to my probation with my ankle monitor. You know what I mean? Just in case for whatever reason they wanted to drug test me or whatever, God forbid that they would do. I mean, and I have a little sister and my mom, and I don't want to keep that image. I really don't, you know? That's why I really would I don't mind doing drug tests, drug classes, or probation or whatever.
All right, and I just asked that because I forgot to bring it up so that could be cleared up because it was in the PSI. So sorry for the interruption.
Okay. No, you're fine.
Are there any other questions?
No more questions.
All right, I'm sorry. You may
Okay.
proceed with your argument,
Okay,
counsel.
thank you. That charge was
Dismissed.
dismissed.
Yes.
Again, as I was saying, I think my main point is that Cullen is a very good candidate for probation. He has no criminal history. He is 22 years old. He has a very, very supportive family. He has friends that he's had since he was in kindergarten that are still his friends. I brought family members and I brought friends that have known him that are not related to him. All of them, including the letters that the court read from his employer and from other people that are friends that are not family. His sister did write a letter. All of them attesting to Cullen's character and their long history of knowing him. That isn't to say that what he did was not illegal and wrong. He should be punished for it. But he should, in my opinion, be punished in such a way that he is rehabilitated. This is a case where, to me, it cries out for rehabilitation, not for prison. Prison would be the opposite, in my opinion, of what should happen. Now, I know that this is a crime that is extremely terrible, and there is a lot of outcry against this behavior. And I agree, it's fine. I'm not opposed to that. But in the appropriate circumstance, and I think this is one, a person that does this kind of crime can be rehabilitated and can go forward and contribute. And of all the people that I've represented for some time in the last couple of years, Colin seems to me to be the best candidate for probation. And I'm hoping that the court will give him that opportunity. Whatever program, whatever monitoring the court feels appropriate, I'm asking the court to give him that chance.
All right, state.
Judge, I respectfully disagree with defense's view that this defendant is a great candidate for community supervision. This defendant has a pattern and throughout this case of hiding and minimizing his behavior. When he speaks with the undercover, instead of putting what he wants to do in a text message, he insists on talking. And he says those things over a voice message, so it's less traceable. He gets there, what happens, he gets arrested. He gets to this court, he pleads on this case to supposedly take responsibility. And when given that opportunity to take responsibility to the PSI officer, instead of just saying, I chose to go there that night, he says, well, she pushed me. The officer pushed me to do it. The undercover pushed me. He blames the undercover, doesn't take full accountability. And even today, he says, oh, well, the reason for that is I was scared. If his reaction to being scared, concerned, anxious, or nervous is to lie, to minimize, that is a terrible candidate for probation because he's going to keep doing it on probation. Judge, the descriptions in this report that the court has in the stipulations of what he specifically says, he's not just saying he wants to meet up and have sex with a 15-year-old. He uses graphic sexual language, graphic violent language to talk about not only physically, but sexually abusing a 15-year-old child, who he fully believes at that time is a 15-year-old child. I understand that this defendant is young. There may be some substance abuse issues. However, Judge, this is not the kind of person who I believe would be safe on our streets. I don't think he's a good candidate for probation, and I would worry about an actual child being harmed if he's let out. So I would respectfully ask the court to deny the applications for community supervision and sentence him under the committee agreement for 8 years.
All right. So, Mr. O'Neill, I want you to know that I heard everything from all of the witnesses. I reviewed the PSI. I've internalized everything. I've read the chat messages that were sent to someone you thought was 15.
I messed up.
Yeah.
I messed up, Judge.
All right. Oh, it's okay if he says something.
I mean, I'm upset about this. You know what I mean? Like, it's just my life, you know? And I mean, I just want to fix it the best way I can.
All right. And I want you to know I'm taking in consideration your age. And I do understand that sometimes people will do things, they're intoxicated, be it through drugs or alcohol. However, in reading the stipulations and in reading the PSI reports, there were so many times that you could have just pulled back.
I did not understand. You know what I mean? I really did. If I had a better understanding, I would have been honest, like I have been today.
No. I'm not even, here's the thing. This is what I understand. When probation officers are interviewing you for a PSI report, there are a lot of things going through your head, right? You don't want to say anything that could hurt you. Sometimes defense attorney, I was a defense attorney, and let me just tell you what I would tell my clients. I would tell them, for the love of all that's holy, just say, my attorney told me not to speak about it, right? And then sometimes I would have clients, I'm like, go ahead, tell them. So I will tell you what is in the PSI. I'm not holding that against you, because sometimes when people are faced with legal decisions, sometimes they get nervous. Sometimes you have a lot of voices in your head. What would my attorney say? I understand all of that. So I'm not holding that against you. that maybe you said something that could be considered you're not taking responsibility. So I want you to know that.
Yes, ma'am.
What I'm talking about is the offense, and it's like there's so many points along the way that you could have stopped, like not drive over there,
Yes,
not go to the hotel,
I agree.
not go up to the hotel room.
I completely agree, and that's something that I've talked to myself and my mom and my family about, and my friends about why I even did it. Because in no right state of mind ever have I ever thought that way or been in a situation like that. I crashed out, and I didn't know what sympathy was for like the situation I was in. I really didn't, and I was young, I was sleep deprived, I was off drugs and alcohol, and I really did not mean to make that decision. And that's not who I am as a person. I've never lied to my mom or people about my situation. I've always been honest when they asked, especially how I got my job back. I had to sit there in front of a bunch of grown people and explain what happened.
Mhm.
You know what I mean? And that's something I can't be unhonest about it because look how it looks on a piece of paper. You know, no matter what I said, no matter what I did, it's what's shown. And I mean, that's what's here today in front of us. Like, and I made a mistake, but I don't believe that I deserve prison because I want to be rehabilitated. I know I can work through what the police says. I know my punishment isn't over. It'll be at least 10 years that I'll have to deal with whatever the plea requires. And I know that.
All right, so this is what the court is going to do. The court is going to find you guilty. The court is going to order Chapter 62 compliance. There's a $3,000 fine, time and money to run concurrently. The court will sentence you to 3 years in the prison, give you credit for any time served. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, what that is, you'll need to speak to an attorney. Do you understand?
So 3 years?
Yes. But like,
Well, I have.
I'm sorry. You talk to him?
Yes, Sharon, but I have another thing I'd like to raise.
Yes.
This is not a 3G off. And
No,
so I will.
I didn't.
Did the court retain jurisdiction?
I'll consider it. I'll tell you what, you can file whatever you want to file, and then the state, you can, make whatever arguments you
May I-
want to make, counsel.
Excuse me, may I hug my mom?
No, you'll have to talk to the deputies. They're in charge of security. Counsel, yes, you can file it and I'll consider it, and I will, once it's filed, if he decides to file it, then of course, the state, you'll have a chance to raise objections if I decide to do it. Thank you.
Judge, may we be excused?
Yes.
Thank you.
All right, and are you ready on Miss Miller?
Yes, Your Honor, we are.
All right, the court is back on the record. And 2025 CR 00144 State versus Havana Miller. The parties please re-announce.
Lauren Espinoza for the state, Jody Sawyers for the defense.
All right, have you had a chance to speak with your attorney? And which do you prefer?
She would take the probation, the conviction.
All right. All right, so the court will find you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Proof of employment within 30 days or full-time study within 30 days. There's to be no employment as a home health care provider or with minors. 150 hours of community service restitution. There's to be anger management. And I'm sorry, what is the class involving animals?
Pause.
All right, the pause class. There's to be no pet ownership. Now, what do I mean about no pet ownership? Not a pet, not a single pet, not even a goldfish. Do you understand?
Yes.
There's gonna be field visits one time per month until further notice. The MRT. There's a $2,000 fine. That will be probated. Probation. Is there anything else? All right, is there anything else you need from the court to be successful on probation?
I would like clarification on how do I prove, my work in my school?
Oh, probation will go over that with you.
That's
right. Anything else?
you.
Anything-
Not this time.
Okay. Anything else from the state? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Here, it's this. Yes.
All right, this is a plea bargaining agreement. You do have a limited right to appeal. That right to appeal is as it relates to any pretrial motions that were filed and ruled upon. Do you understand?
Yes.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. Animals are helpless, right? And they depend on you to provide for them. And if you don't have the patience to have a pet, then guess what? You shouldn't have a pet. The end of story, because they depend on you for food and everything. And maybe people shouldn't be beating horses as they run around the track at full speed. I don't watch it, right? But our society doesn't equate racing a horse around the track with pets, right?
Yes, ma'am.
Bullfighting, should there be bullfighting? But they don't equate that with pets. Maybe one day they will, but for now they don't. And so you're not allowed to have any pets. And you're not allowed to babysit children. You're not allowed to do any of that. Do you understand? All right, there is a pause. Are you babysitting?
I have nieces and nephews and I've never done anything to them.
No, you're not allowed to babysit. And let me just explain to you why I'm saying that. Because your patience with your pet, you lost it. And at this point in time, you cannot babysit children at all. You understand?
Is that just during probation? Or-
Yeah, I mean, I can only order what I can order and no gum chewing. I can only order what I can order while you're on probation. So for these 8 years, yeah, no babysitting. Okay?
I do have a question, I'm sorry.
Yes.
If I don't plan on it, but 8 years, I'll be almost 30. If I wind up pregnant or have my own child at that time, what was, what's the difference?
Here's my thing. I always tell people, let's not cross bridges until they're built.
No, it was just a
Yeah.
question.
No, that's what I'm saying. I can't see in the future. I don't know how you're gonna be doing on probation.
Right, but would I be like in violation?
What she's saying at this point is she's gonna.
Just don't let it
label it. If it becomes an issue, we will.
And your attorney can approach that on, because you can see there are many circumstances where you're telling me that. And then maybe it wouldn't be appropriate, but then if it wasn't appropriate, Child Protective Services would probably be involved, right?
Okay.
So I can't look into the future and see how you're gonna do, but what I can tell you is we'll cross that bridge if we come to it, all right?
All right.
All right, thank you.
Thank you.
You're welcome. All right, who's here on Gandarelle?
Present, Your Honor.
And then on Ashley Jones, I just got the paperwork, so I'm signing that. Court is calling 2025 CR 006-612-02. State versus Luis Antonio Gandaria Jr.
Andaria Junior.
I can't roll my R's.
It's kind of hard.
Oh, yeah. All right. Can I have parties announced?
Megan Galloway for the state.
Renee Munoz on behalf of Mr. Candaria.
And are you Mr. Gandaria?
Yes.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that is correct.
Are there any applications?
No.
Court will find that the state is in compliance with discovery. Mr. Gandaria, did you review the did you review the true bill of indictment with your attorney?
Yes,
It tells what you're charged with. Did you review that?
yes, Your Honor.
Did you understand it?
Yes, I did.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on it as presented?
We waive the punishment in instance, Your Honor.
No objection.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did, Your Honor.
You're charged with unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I did, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
I did.
And did you intend to give up those rights and enter into a plea in this case?
I did.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Mr. Gandaria, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Very satisfied.
If you're not a U.S. citizen, by entering into this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 223 days in the Bexar County Jail. There's a $1,000 fine. They're asking that that punishment be assessed under 1244, and there are no applications. Did you understand that to be the plea?
Oh, yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offer states one in attachments.
No objection.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it
I did,
in
Your
all
Honor.
the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask that the court follow the negotiated plea bargain agreement, Judge. He has made some questionable decisions in the past, but he is going to learn from them. He assures the court this won't ever happen again,
It won't.
and he's going to make much smarter decisions in the future.
All right, the court will sentence you to 223 days in the Bexar County Jail under 1244. Give you credit for any time served. There's a $1,000 fine, time, and money to run concurrently. Is there anything else with regards to sentencing?
Nothing further from the defense, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
I understand, Your Honor.
All right, we can go off the record. How old are you?
I am 34.
All right, so you're old enough to know better.
I am, but
So-
I help a lot. I'm sorry, and I helped this one person, and I should have then took her word, and I took her word, and that's why I have my cousin.
You got to protect yourself, though, right?
Yes.
Mhm.
Can't be doing things that are opening yourself up to liability, and then you're the one in trouble. I don't see her here, right?
I know, and it's
Well, wait a minute, there she is coming through the back. Yeah, no, turn around. There she is. Now, see, that's what I mean. You're out here on your own, okay?
I know.
All right, make better decisions. Good luck to you.
Thank you.
All right, bye-bye. All right, who's next?
Page 65 down, Judge. It's last name is Patty Steve. I can't understand it right.
Batty Jones?
Yeah, oh, not cute.
Who's here on Batty Jones? All right, what is happening on Discovery?
Your Honor, we're good on discovery. We do need to investigate some of the lab that came back. We have an offer from the state and he's considering it. And then at the same time, I'm gonna look into the lab report.
All right, Ms. Ferguson, set this for a plea deadline date in 30 days, please.
Yes, ma'am, I can do.
Yes, that works.
Yes.
All
right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you. Thank you.
You're welcome. Who's next?
It is, page 6, oh, I'm sorry, page 8, 2 down. Harrison?
Who's here on Harrison?
Judge, if we're set for trial, but, and I think you said you hear the suppression motion on day trial. And I made a slight mistake, it could be easily fixed. The video that I was provided apparently had 2 different offenses from different dates.
Okay.
And I looked at the first one, all involving essentially the same room, same individuals, 2 different dates. But the second one is the one that this case is based on.
Okay.
And the first one had the entry point of the officers, which was completely unlawful, but I have a second one too. But they conveniently cut off the portion where they go into the room. I have the video number. I did a motion for discovery. I just need access to that portion of the video right before.
Okay, can you make sure he has access to the portion of the video he's speaking about? Norma, recall her for tomorrow and she's to be dressed. Thank
Would
you.
we be picking a jury tomorrow, Judge?
Yes.
Thank you.
All right, who's next?
It is Anthony, Joe Longoria. 4 went down, so.
Joe Anthony Longoria. Hello.
Hello, Judge, how are you?
All right, how are you doing? Long time no see.
Good, Judge, just need to run to the dentist.
Ah.
I texted them I was gonna be a little late. A few days ago, Judge, Mr. Longoria, the state released additional discovery for Mr. Longoria. We talked about it today. They believe that is all that is relevant, those documents. I need to review it. But fortunately, we also talked about another plea bargain and we amended that plea bargain, Judge. So I just need time to review the discovery, make sure nothing's missing, but I do anticipate that kind of regardless, after I talk to Mr. Longoria, that we may end up doing that plea bargain, Judge.
All right, Ms. Ferguson, set this for the first week in November for disposition.
Judge, I need a little more time than that. I mean, they released to me hundreds of pages of documents.
All right, Ms. Ferguson, second week in November.
Yes, ma'am, I think you November 15th.
All right, we'll see you back on November 13th.
I'm set in Hayes that day, but could we do the 10th or the 18th?
All right, November 10th.
Thank you, Judge.
All right, thank you. Once you sign the reset form, you're excused. Aristide Brown. Good afternoon. Good afternoon. Why are you late for court?
I wasn't late. I went to the other court first.
County Court 5. All right, so district court takes precedent. So where are we on this case?
Your Honor, there's 3 indicted cases, different offense dates. I emailed Ms. Galloway a request for body worn camera of 3 different officers. I gave the officer's name with their badge number and a dash camera for one of them. On one particular case, there's a second case where I believe I'm missing a video. I discussed that with Ms. Galloway. And one file alone is, there's 267 gigabytes. One file has 72 videos. I've looked through those videos. I don't see the videos I'm looking for.
Okay.
But there's tremendous evidence if I can have a discovery reset.
All right, Ms. Ferguson, I need a 30-day reset for discovery and state. At that time, you'll need to be prepared to tender an offer.
Yes, Judge. I can do that December 4th.
December 4th.
All right, December 4th, once you sign the reset form, you're excused and court style, it's at 9 o'clock and district court takes precedent over misdemeanor court.
And
Okay?
we got the misdemeanors resolved.
Ah,
Uh,
So there'll be no issues.
Just this court.
All right, thank you. Matthew Warris.
Good afternoon, Your Honor. We are here asking for a little bit more time for Dr. Fabian to conduct his psychiatric evaluation. We have strong suspicions of an intellectual disability. That does have some paperwork behind it. I spoke with Dr. Fabian's office this morning. They said the fastest they can probably get us in would be next month. I'm respectfully asking if the court would consider a 45-day reset, and I'll really push him. But we cannot proceed without the psychiatric evaluation, Your Honor.
So I was told, and maybe there's some confusion, but I was told it wasn't Fabian, that it was someone else, Murphy or somebody.
Your Honor,
Is that
our
for a
order
different case?
appointing expert was for Dr. Fabian.
All right, I think your co-counsel got it confused. He was telling me of something about a Murphy or McMurphy or something.
Joanne Murphy.
I'm sorry, who?
Joanne Murphy.
Yes. So this is not Joanne Murphy.
No, Your Honor, this is Dr. Fabian. I remember getting that order signed specifically.
Thank you, Sydney. I was like, am I losing my mind?
Apologies.
No. All right. So I'm just gonna give you a 30-day reset and that's it. And if that person doesn't have that by then, they should have it by then, because we've been waiting on this for a long time. And the court has continually given resets. And so if for some reason it's not ready by the time the court gives this reset, then they need to be here and they need to explain why it's not ready.
Understood, Your Honor. Just as a small background, we did have another expert on this case, David Gallant. He has concluded his services. So we have been moving it, but I will express to Dr. Fabian that it needs to get done.
All right, Ms. Ferguson, I need a 30-day reset. There will be no further resets unless that doctor comes in and testifies as to why they're not ready.
Understood, Your Honor. December 4th. I will take it.
Thank you.
Thank you, Your Honor.
Yes. All right, why were you late for court? I'm sorry.
I was at work, I wasn't informed.
Well, that's really not what he's asking. She's asking, did you have notice?
Oh, no, ma'am.
We had no notice and I didn't either, Judge. That's why I was saying up at your staff. I got the text late this morning, called him, asked him if he was in court. He said no. I said, well, we're supposed to be there. We got here.
So here's the thing, if you didn't receive notice, that means that the address that is in the system is incorrect, and the address that is in the system is the address that you gave. So you need to make sure that is correct. Where are we on discovery?
I need to view the additional discovery that I think has been uploaded, but I need to review it with Mr. Radler as well.
All right, Ms. Ferguson, I need a 30-day reset. All right, and so state, you'll need to be prepared at that time to tender an offer.
Yes.
All right, once you sign the reset, it's on your excuse.
Thank you, Judge.
You're welcome. William Waddell. Court is calling 2025 CR 011436 State versus William Waddell. Can I have parties announced for the record?
Rick Pena for the state of Texas.
Albert Chidas from Mr. Waddell.
And are you Mr. Waddell?
Yes.
Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
We did, Judge.
Court will find that the state is in compliance with discovery. Mr. Waddell, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We're proceeding on paragraph A, Your Honor, we'll waive paragraph B.
Any objection?
No objection, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with the offense of burglary of a habitation. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, The court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
I'm sorry, Judge, I was,
It's okay.
getting something from the DA. What was your question, Judge?
Has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Waddell, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. There's to be no contact with the complainant or the address. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending your community supervision before a term of 8 years. There'll be 200 hours community service restitution, the BIPP course, TAP evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to
Your
the,
Honor,
yes,
I apologize for interrupting, but I just thought of another recommendation I think would be appropriate. And that's what I was relating to defense, given the stipulations. I think that make evaluation and recommendations would be critical.
And we have no objection, Judge.
And if you need me to print out a new sheet with that.
no, that's fine. All right. Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, defense, the present the evidence, states exhibit 1 with all attachments.
No objection.
All right, and have you spoken with the complainant?
We have, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
All right, so what happened? Is there do you have any prior mental health issues? What was going on?
No, ma'am, after I divorced in 2020, alcohol and substance abuse really got a hold of my life. Had a very bad night. My uncle was to be buried the next day. Next to my dad had passed away when I was 19. I took it really hard. I made some really regrettable decisions. And yeah, I've since been to alcohol and drug rehab, done intensive outpatient for 8 weeks after that for both mental health and substance abuse. And I continue that to this day.
And Judge, he, before all this happened, he was a college-educated marketing consultant for a large firm. He hopes to get back to where he used to be. I think that he's an excellent candidate for deferred adjudication probation. He's got a lot going for him. He's got family support, and hopefully we'll be here before this court in the future asking for early termination if he does come, which I think he will.
All right. Do you have any children?
No, ma'am.
State? Has he had any contact with the complainant since this?
None that the complainants relate to us. We spoke with her this morning. She didn't indicate any type of that behavior.
All right. Is she in fear of him?
Yes, to an extent, I would say, given the night, but I think she mainly was one, as I would assume he wants to be done with this.
All right, this is what the court is gonna do. Thank you. There's a $1,500 fine that will be probated, 8 years deferred adjudication, regular reporting by Zoom or in person, proof of employment within 30 days, no employment as a home health care provider with minors, 200 hours of community service restitution, the BIPP course, field visits 1 time per month until further notice. There should be no contact with the complainant or the complainant's address. And is he currently on GPS or no?
I don't think so.
Were you ever placed on GPS?
Judge, I was gonna ask something. Long ago, we asked for permission for him to move to Longview.
Mhm.
So he's been living in Longview this whole time the case has been pending. I would just ask the court for permission for him to transfer his probation to Longview.
All right, be a transfer to Longview. And as previously stated, the complainant, you're not to contact her by phone, you're not to go by to her house, you're not to send an apology letter, nothing. Do you understand?
Yes, Your Honor.
All right, and then there's a transfer to Longview. Probation and also a TAP evaluation. And MIC evaluation. Probation, is there anything else?
Judge, with the transfer, we're not gonna be able to do those films.
Okay. Is there anything else? Is there anything else you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Before you get into any other relationships, you need to make sure you work on yourself. You understand?
Yes, Your Honor.
All right, good luck to you. You're welcome.
Thank you, Your Honor.
You're welcome. All right, DeMar Clark.
Big busy day.
Oh, yeah. It has to.
It's get a dog and get
Oh, we've had everything. So he's scheduled for jury trial.
So they re-indicted him yesterday,
Mhm.
and I'm asking for a reset. 10-day notice.
That's it.
All right, so it's been re-indicted.
Yeah.
Re-indicted yesterday, Your Honor.
All right, Ms. Ferguson, I need a reset for 10 days for jury trial. All right, November 10th. Thank you for dressing appropriate for court. Once you sign the reset form, you are excused.
Thank you, Judge.
You're welcome. Liliana Portillo. And this is an application. Court is calling 2025 CR 011157, State versus Liliana Portillo. Can I have parties announced for the record for the state?
Ray Lopez for the defense, Your Honor.
Off the record, Mr. Bonk, I'm requesting that you go to breakout room number 1. All right, we're back on the record. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Portillo, did you review the application for community supervision with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, did you review the true bill of indictment with your client?
Yes, Your Honor.
And Ms. Portillo, have you reviewed the indictment and did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Portillo, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Portillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes.
Did you understand if you're not a U.S. citizen by entering into this plea bargain agreement, you will be deported, denied naturalization, and re-entry? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $1,500 fine. There's no application for deferred adjudication. The state recommends community supervision. They're taking in consideration 2025 CR 011803. There's to be restitution to the Bexar County Lab for testing in 2025 CR 011803. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, 120 hours community service restitution, random UAs, MRT, and anger management in the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plea?
No contest.
State any evidence?
State offers and evidence exhibit 1.
No objections, Your Honor.
All right, state, you may be excused.
Thank you, Your Honor.
Oh, do you have the dismissal?
Yes, I do. I have another one too. I needed to take it for the
All right, thank you.
Thank you.
Did you review the waiver and consent to stipulations of testimony and stipulations with your attorney? Did you understand it and did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked that the court follow the agreement.
All right. So who is Rodolfo Rivera? All right. And who is Cynthia Gutierrez?
I don't know. Cynthia.
All right. And Shakira Tiona Patina?
Oh, that's my best friend.
Okay. Do you have any children?
I do.
And what are their ages?
12 and 6.
And do they live with you?
The 6-year-old does.
All right. And where does the 12-year-old live?
With his dad.
So who all lives in your household besides you, the boyfriend, and the 6-year-old?
My mom and my sister.
Okay. All right. This is, and if you're drug tested today?
Negative. I do random UAs with CPS.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's to be CPS compliance. There's to be no unsupervised contact with minors. If you want that to change, counselor, she wants that to change, the CPS worker needs to come in, or either the child's ad litem. There should be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There should be no employment as a home health care provider or with minors. Take in consideration 2025 CR 011803. There should be restitution for drug testing in 2025 CR 01183, and that's to the Bear County Crime Lab. There should be a TAP evaluation out of custody. 120 hours of community service restitution. Once you complete parenting, that will be deemed satisfied. Probation, if CPS is having her complete parenting classes, that can count towards the parenting classes here. And the MRT and field visits 1 time per month until further notice. Probation, is there anything else? Is there anything else you need from the court to be successful?
No.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to make sure that you speak to your attorney. Do you understand?
Yes.
All right, we can go off the record. So you have CPS case, right?
Yes.
I don't need to tell you, you need to make sure you stay in contact with your attorney over there. You need to make sure that you do everything that's required of you over there, because if you don't, that's a violation of your probation here. And if you don't, you could lose custody of your child. You understand? All right, in this court to be successful, communication is key. If there's an issue, let probation know. If you feel they're not addressing it, you can always come back to me. If you feel that you're going to use, pick up the phone, call your probation officer. You understand?
Yes.
All right, good luck to you. Who is here on Jacob Andrade?
I am, Your Honor. And I was actually talking with Lauren about someone else.
Okay.
Can I get very quick?
Sure.
And we're ready on Andrade. We have Omar Herrera that was a contested MTR.
Mhm.
We've actually worked it out. And we can't do a plea because it's a plea of true on a new offense where the state's still working on the prosecution guide. It's going to be a waiver plea.
Mhm.
And we've been waiting 3 hours.
Yeah, so at the lunch hour, Judge, we reached out to the detective that is assigned the case, and he's actively writing his proscribe to submit it to us. We just haven't received it yet, so that's still hold
All right, who is this again?
Omar Herrera, he's an inmate, so we're not asking to reset it, we'll just recall it.
Okay.
And I don't know,
Is he on the docket today?
yes,
All right, look.
it was gonna be a plea, and it looks like the report won't be made in time.
So when do you all want to recall this for disposition?
If it's sometime this week.
Yeah, I imagine he'll get it to us within the next day or so. He's actively working on it.
You all want to say Thursday? All right. Is that good? All right, Ms. Ferguson, on Omar Herrera, if that can be recalled for Thursday.
Yes.
And probation, there's no application in this case. Court is calling 2025 CR 008600 State versus Jacob Andrew Andrade. Can I have parties announced?
Megan Galloway for the state.
Joseph Davidson standing in for Monica Guerrero. Mr. Andrade, will I have permission to do this in place of Ms. Guerrero? Your permission?
Yes.
Thank you.
All right. So counsel, have you received all discovery and did you review it with your client?
We have.
Court will find that state is in compliance with discovery. Mr. Andrade, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
All right, so Mr. Andrade, I'm gonna need you to speak up a little bit so that the court reporter can hear, okay? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented? Any objections?
No, Your Honor.
Mr. Andrade, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Do you understand you're charged with robbery? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes,
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand by entering this plea, you're giving up those rights?
yes,
And did you intend to give up those rights and enter into a plea in this case?
yes.
Off the record for a moment. Ms. Shaw, if you go to breakout room number 1, that's where your client and Mr. Bonk is.
Yes, ma'am.
Thank you. All right, we're back on the record. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Andrade, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $2,000 fine and no applications. Did you understand that to be the plea?
yes,
Defense?
Yes, Your Honor, and with credit for time served.
All right. State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
no,
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest.
State any evidence?
State offer states 1 in attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he wishes to do his time. He is asking for his back time credits. We have this agreement. We hope that he follows it.
All right, the court will follow your agreement, sentence you to 4 years in the prison. You'll receive credit for any time that you've been in custody. There's a $2,000 fine. Time and money will run concurrent. There's to be no contact with Family Dollar.
At that particular
At
location.
402 Southwest W. White Road, 78219. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes,
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
yes.
All right, you're gonna have to make better decisions, otherwise you're gonna find yourself in and out of prison. Good luck to you.
Thank you, Judge.
Malik Lampton. Lampkin,
He's on page 3, Judge.
all right.
About to sign up?
I just go by what people give me.
Hi, Judge, how are you?
Hi, I'm doing okay. So on this one, there's all right, this shouldn't be a motion. Why is there a motion to reinstate bonds?
So, Your Honor, Mr. Lampkin was arrested this morning during docket on a warrant, that defense was unaware of, for a new case that he picked up while he was,
But did somebody,
we were preemptively trying to get ahead of. it.
no, there's no need for this because it should come to me for a bond.
Okay,
So the only thing it is for the new case, is that correct?
that's correct.
All right,
Yes.
and so what is the case number on that? Because all of these are reinstate bonds and
We have, 2025 CR 012 912
9 what?
912.
All right, and do you have a motion for that?
Yes, Your Honor. We have a motion to recall warrant for set bond.
Well, it's gonna have to be a bond that's set.
Okay.
So do you mind, because a bond hasn't been set, correct?
No, Your Honor. We would ask the court consider setting a PR bond based on the circumstances that this case did happen while Mr. Lampkin was in custody.
So based upon what he's charged with, I'm not allowed to set a PR bond, but I understand what's happening here. I think everybody understands. Do you have any objections to me, to my renaming your motion to set bond?
No, Your Honor. Thank you, Judge.
All right, so the court is aware of Mr. Lampkin's history with mental health. The court is aware that he was, he had received a bond on his other cases. He was released and that he was doing very well because he was on the correct medications. The court understands that when he was taken into custody on a warrant, he was not on his medications. That's why he ended up being taken into custody for certain alleged violations. And since that time, he has been doing very well. So is there an agreement on a bond amount?
Yes, Your Honor. I confirmed with Megan and we agreed on 10,000.
Is that
That's correct, Your Honor. Yeah, I've taken into consideration the safety of the court.
all right? So the court will set your bond at $10,000 then. And there are other previous conditions that are in the other bond. So Mr. Lampkin, I don't think they'll be able to do satellite or anything. Is that correct?
I don't believe so, Judge.
All right, so here's the thing. You have your bond set. Your attorneys will take care of it. You'll probably be released at the latest, maybe tonight at midnight if they can get everything done, or at the latest in the morning. You understand?
Good.
All right, so there is nothing to worry about. Nobody's forgotten about you. And if for some reason you're not released by tomorrow, your attorneys can come back here and we can see what's going on, all right?
Okay.
All right, do you have any questions about anything? All right, I'm sorry this happened because you were doing very well. So sometimes things happen and we just have to handle it as they come, all right?
Good.
All right, thank you.
Judge, there's one last matter.
Mhm.
I don't know if you would prefer us to get a setting to come back later in this week once Mr. Lampkin has been released. Similar to the travel that you granted last weekend, Mr. Lampkin would like to go trick or treating with his little brother, his mother, and his grandfather this weekend on Halloween.
We'll need to, well, I understand that there are issues and that he does better when he's with his father. So if you can take, once he's released, just come back and take it up with the court.
Okay, I can do that.
And if you are unable to come back to court, if you'll discuss it with the state, I'll docket. If they're in agreement, they'll give it to me. If they're not in agreement, we can have a hearing and we can do that hearing by Zoom because I know Halloween is almost upon us.
Okay.
All right. And Norma, just put this for October 30th because I want to make sure that he's been released.
And for a big deadline, like today, Judge, or?
Yes. All right. Is there anything else?
No, Your Honor.
All right. Thank you. If you'll have them make you a copy of that so you can take that.
Okay, thank you, Judge.
If you want me to give him what he said?
Antonio Garcia? All right, so what is happening? Why is he in custody?
Just my understanding that he had a violation report.
Okay.
I think we all remember last time he's been working on his sobriety and he was doing outpatient with lifetime recovery. And it would seem that he relapsed and had a positive test for cocaine.
Okay.
And so that's the reason for the violation report.
All right, can I see the violation report on Mr. Garcia, please? Yes. If you can have a seat and if you can go in the back and just grab the
Grab it.
violation report.
Yes.
Okay, all right, just have a seat and we'll take this matter up.
You have something to say, but. Wait.
All right, Carpenter,
Ready, you are.
are you really ready, Mr. Porter?
Super, super ready.
I always appreciate your patience.
Somebody left.
Mr. Carpenter, come down.
Who is this? Who did this case?
Which one is it?
I can't pronounce last name.
Oh, that is,
They just left it so.
I know who it is.
I hope so, you did it.
No, the attorney is, Brian Kimbrough.
Oh. Do that one.
All right, the court is calling 2025 CR 008-179 State versus Paul Carpenter. Can our parties announce?
Melissa Alvin for the state.
Robert Porter for Mr. Carpenter.
And are you Mr. Carpenter?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Your Honor.
And did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Carpenter, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Carpenter, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge. I did.
You're charged with possession of a controlled substance penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, it appears that you're going open to the state. So the full range of punishment is open to the court. Do you understand?
Yes, ma'am, I do.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Carpenter, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I got.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is open. The only thing that you all have agreed to is that there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Yes, Your Honor.
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then how do you plead to the offenses charged?
I believe guilty, ma'am.
Any evidence?
State Office in the evidence states Exhibit 1 and
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, just 1 second. Okay, they're still there. All right, again, did you understand, by signing that, you're giving up your rights to a jury trial, you're giving up the rights to cross-examine witnesses and the right to remain silent?
Yes, ma'am.
So what that means is that the state is going to be presenting evidence in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Yes, can I reserve time to say?
Your Honor, we're asking that you impose, if not the max, something close to the max. This case is state jail felony. However, it could have been indicted as a repeater based on his state jail repeater based on his criminal history. We could have re-indicted it. We chose not to work it out this way, or filed notice of intent to seek the enhancement. He has a very lengthy criminal history, and we think that would be a fair resolution.
And what is the criminal history?
He's got some juvenile stuff I'm gonna skip over. Yes. For time. He has been convicted of interference with an emergency phone call. Failed ID. That looks like a class B failed ID. A bird cab. He did 5 years for a bird cab in 2011. Looks like there were 2 counts of that and they ran concurrently. He also was convicted of a second degree drug case, 4 to 200. He did 30 months confinement for that. Another failed to ID fugitive, a less than a gram that he did 9 months for. Fraud use that he did 9 months for in 2018, a UUMV that he did 8 months for in 2019. Another fraud use in 2022, he did 2 years for. And several other cases that, a few other cases that are still pending and I think in flux, as far as I know. And I think there's reference to them in the police report that we tendered in the STIPs.
I don't know where to start, but I'm gonna start with this. It's 0.14 gram. This same district attorney's office, just a short time ago, was dismissing cases under 0.25. Now they're stepping in and asking the court to do jobs that they didn't do. Having said that, Judge, yes, he has a lengthy criminal history, but we're not here for those cases. We're here for this meth case. He's pled guilty in front of this court, and that's what he's did. He hasn't been sitting in jail doing nothing. He's been in jail actually 203 days. And what he's been doing is he took the mental health recovery program. That's number one, because as the state had pointed out to me, he at one time was considered a gang affiliated. By taking that course, he is no longer gang affiliated. That's why he's also dressed in orange. The course he took was that mental health recovery program, which helps you to handle situations, communication skills. It was AANA to get sober. They also put him on Suboxone to help him with his drug treatment. His mother right now, Judge, was going to be here today, but she had surgery on the 14th, back surgery, so she couldn't be here. We're respectfully requesting, Judge, that we're here for a state jail felony of 0.144, and I'm not belittling that, other than it's the smallest amount I've seen in a long, long time. We're respectfully requesting that this court sentence in the lower range.
All right, so I'm reading the police report, and I will tell you, Mr. Carpenter, I do consider criminal history, because I always tell people criminal history is like a credit report, in the sense that should I loan this person money, will they be able to pay it back? Let me look at their credit history. And criminal history is sort of like that, in the sense of, should I give this probation? Should I not give them probation? What should I sentence them to? Because you look at it to see how they've done in the past, right? So here's my question, and nobody's answered it. Does he have, based upon what I'm reading, are there cases that are still pending or not?
I think, Judge, Well, I'll let the state go.
Sorry, that's why Rick is here, Your Honor, because those were family violent cases, and so he was gonna speak on that.
Yes, the defendant does have 2 burglary charges and a repeat BPO charge pending that. Unfortunately, due to victim uncooperation at this time with our office, they have not yet been indicted. We are still within statute though, so at some point in the future, they may get indicted, but unfortunately, it doesn't appear that in the immediate future will be indicted on those.
Which is why, Judge, if I may, which is when I took over this case in the courts, I was threatened with all these cases. They have done nothing with these cases. And what they're doing now is stepping in and saying, Judge, please do the job that we can't do.
All right, this is what the court is going to do. The court, as previously stated, the court is finding you guilty. The court is recommending the therapeutic community. There's to be no contact with, I thought I didn't see it. The complainant's name is not even fully in the report. So who's the complainant?
In this case, it's the state of Texas.
No.
That
I mean,
that wasn't
for
the
the-
only report, Your Honor, but since we were only proceeding on the drug case, I didn't include the entirety of the rest of the case.
And the court will sentence you to 14 months in the state jail facility and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Judge, I did.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, we can go off the record. So, Mr. Carpenter, I want to let you know that I really listened to your attorney's argument, and your attorney did make good arguments. But you are going to have to continue on the path that you're on. Otherwise, you're going to end up right back here. You understand?
Yes, Judge.
All right, good luck to you, okay?
Yes, ma'am. Thank you.
You're welcome. Billy Reynolds? All right, the court is calling 2025 CR 010492, State versus Billy Joe Reynolds. Can I have parties announced?
Megan Galloway for the state.
Deborah Stantonberg for the defendant.
And are you Mr. Reynolds?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
And probation, this is an application. Court will find that the state is in compliance with discovery. Mr. Reynolds, did you review the application for community supervision with your attorney? Did you understand it and sign it?
I did, Judge.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes, we waive it.
State, are you proceeding on the indictment as presented?
We're waiving the punishment.
I'm sorry, could you repeat that?
Waiving the punishment enhancements, Your Honor.
Any objection?
No, Judge.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Reynolds, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No,
Are you satisfied with the way you've been represented?
I am.
Did you understand if you're not a U.S. citizen by entering into this plea, you will be deported, denied naturalization, and re-entry?
Yes, ma'am.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's $1,000 fine. State recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be 200 hours of community service restitution, TAP evaluation, no contact with Oscar Ramirez or Jade Ward. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
The offer states 1 in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, we hope so.
Anything you wish to say on behalf of your client?
We certainly hope that you follow our plea agreement. And my client was arrested this morning when he appeared in court. He was supposed to come Thursday. Of course, I contacted Norma on Friday and asked, could I bring him Tuesday? He came today because he didn't know court was Thursday.
Okay.
But he came when I told him.
Okay. So when's the last time you've been employed?
Gainfully employed, probably 2011.
All right. So what do you do? How do you support yourself?
I get a small pension from the military and also disability. I'm service connected disabled.
Okay. And so when did the drug use start?
It's been a long time ago. It was sporadic back and forth.
Mhm.
Went through treatment. It worked. Become bored after a few years and started using it again and then dropped it again. Well, I quit drinking in 2000 and I hadn't picked up a drop, but it was sporadic with the drug use.
Okay. And so do you have a home to live in?
Yes, ma'am.
And the people that they say no contact, were these people that you were hanging around with?
No, the one person, no, I just barely even know him. But
Oscar, he doesn't know.
yeah, Oscar, but Jade is a personal friend, very close to.
And he hopes that you won't impose no contact because he actually helps her and her son. Like he was supposed to pick up her son from school today.
Yeah.
They're just really, really good friends. I understand that it's not in the plea agreement, it's recommended by the state. And we hope that the court will let him have contact, but order.
I'm not trying to make more work for you or her.
No. Let me just tell you the reason why I'm not going to allow contact.
Okay.
Because this is a drug case.
Yeah.
I mean, you really shouldn't be picking up children from school. This is a drug case. And, until you prove to the court that you can be clean and sober and stay clean and sober, can't have that.
It makes sense.
Okay. All right. The court is finding you guilty. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's $1,000 fine to be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment or
disability.
Okay, stop. Interrupting. Sorry. All right. So proof of employment
Yes, ma'am.
within 45 days or proof of your pension or retirement within 45 days. If you're not able to provide that proof, then you're going to have to get employment. There's to be no employment as a home healthcare provider or with minors. There's to be no unsupervised contact with minors. There's to be no contact with Oscar Ramirez
Mhm.
or Jade Ward. There's to be a TAP evaluation out of custody. 200 hours of community service restitution. And for every sober support meeting you complete, an hour will be deducted from your community service hours.
I'll explain to you.
Okay.
Field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court?
No, ma'am, I think you covered everything.
All right, and Deputy Laura, you can recall the warrant. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Oh, and probation, if you can do a referral to Veterans Treatment Court. All right, good luck to you.
Thank you, ma'am.
Oh, you're welcome.
Thank you.
You're welcome. Have a good one.
May I be excused?
Yes. All right, Randy Folsom. Who's here on Randy Folsom? And where's Mr. Folsom? Hello.
Hi, Judge. Good afternoon.
Good afternoon.
How you doing?
I am doing fine. All right, so in this case, the competency evaluation, has that been completed?
It has, Judge. Came back as confident.
All right, and are you the first attorney on this case or the second or?
I'm the second attorney, Judge.
Mhm.
Previously, I believe Mr. Leal was on his case, but he didn't show up a couple of times.
Okay.
I think the MAC put me in his stead at that point, Judge.
Mhm.
But there's been some issues with communication, in my opinion. I don't file motions to withdraw often. In fact,
I know,
believe
I've
that
never seen one.
This is the first one in your court, Judge, so it's not a reason for delay. But I feel like the attorney-client relationship in this circumstance of Mr. Folsom has deteriorated. He's not heeding any sort of defensive advice from me. And I don't know the reason why, but I just feel like representation with Mr. Folsom moving forward would not afford him the best defense, being that he's in like the cut of my jib. Whatever
doesn't
reason it
like
may be,
what?
the cut of my jib, like the way the way that I am, just I don't know what's the
So
reason.
here's the thing. In the words of John Wayne and Cowboys, we're not here to make friends. Everybody is here to do a job. Nobody's inviting you to their house for dinner. Defense attorneys, and I've been a defense attorney, they can't force the state to give a dismissal if you think you should have a dismissal. They're not holding one in their back pocket. Your attorney will look over the facts of the case and they will say, hey, this is what the state says they have, right?
Mhm.
And normally what I can tell you is in police reports, when police reports are filed, usually people expect people to say what's in the police report. Like, for example, this is a DWI third. Nobody's expecting the police officer to come in and say, you know what? Actually, I didn't see any signs of intoxication. That's just going to be up for your counsel to cross-examine them.
Mhm.
So I don't understand this about bedside manner or whatever.
Well,
Yeah.
you know, I was in the driveway at this house.
No,
and-
here's the thing. No, here's the thing. We're not here to talk. We're not here to talk about the facts of the case.
No,
But this,
facts.
this is what I will tell you, what I've discovered too,
Mhm.
which I don't know who came up with this idea. People think if they're alleged to have committed a crime, if they make it to their house,
No, that's not
everything's
that.
okay. But so here's the thing.
Mhm.
Your attorney doesn't have to be your best friend. Your attorney's not trying to be your best friend.
Best friend.
All right, so I'm sure he's told you what he
Okay.
thinks are the good points about your case and the bad points about your case.
Mhm. But I was there. He wasn't.
Well, then that
And,
means, do you want to testify?
Like I said, yes, ma'am.
Okay, then he'll give you,
It's just, it's been
It's,
a combative nature throughout the whole course representation, Judge. We were in court earlier and he was being loud and verbally abusive. I just, it's, I think, difficult to proceed moving forward. Every specific defensive advice I've given has just been heated with the combativeness. So I don't know, maybe he might have better luck with a different attorney. I think he's requesting, I had my colleague speak to him as well, and he communicated to her that he's requesting a different attorney, which is why I filed this motion.
So are you gonna hire an attorney?
Probably not. You know why? Because I've been locked up for going on 16, 17 months.
Mhm.
And everything's been taken away from me.
Mhm.
And I don't think I did nothing wrong, tell you the truth. And you know, um here it is again, the same old thing. And it's always up to somebody else to make a decision.
Mhm.
And you know, I'm sick of it.
Okay, all right, you can be brought, you're scheduled for a bench trial
Mm-hmm. A bench
So-
trial for what? And I would
for
like
these
to know where,
charges.
what charges?
The charges that you're here for. You're here because you've been accused and indicted for driving while intoxicated, third or more.
Mm-hmm. Okay,
So-
where's my vehicle? Is what I'd like to know. It was took out of my driveway for evidence. And I'd like to know.
Your Honor, I
where's
let him
it at.
know that it was towed and it's at the Groundon lot.
I told him right when I met him that the car was taken out of my driveway from the police officers and the record. And nobody has told me anything about it. I've asked about the gash in my arm right here from the police officer and the nurse over there on SAPD. Nobody has said nothing about that, but everybody continues to do whatever they want. But you know, I'm trying to find out where's the good faith based people at.
Yeah. I understand what you're saying.
I mean, I think a lot of it's been brung in bad faith.
Mhm.
Let's go ahead and put it to where I was evaluated. There's nothing wrong with me.
I'll tell you,
Okay.
sometimes people will be evaluated because legally,
Mm-hmm.
if you feel that someone should be evaluated and they're not evaluated, and then you go through a jury trial or whatever you go through, and it doesn't turn out the way someone wants it to be,
Mm-hmm.
then that can be appealed on grounds that, hey, this person should have been evaluated. What were you all doing? So this is what we're going to do. I'm going to have you recalled for tomorrow, and I'll take up that. Are you going to be here tomorrow, counsel?
Yes, Your Honor.
All right, I'm going to take up this motion tomorrow. Deputy, have him dressed tomorrow, please.
And that's another thing right there, Your Honor. The family member took my dress out clothes to the office right here. It's never been showed up over there at the police
Oh,
department.
sometimes
Sometimes.
as it happens.
Yeah, it happens, you know. It does like everything else. And that's how come I'm sorry that I'm not dressed properly.
No, that's okay.
can make the
They're,
proper
they're,
But it's been 6-7 months.
yeah, we're going to make sure that you're dressed properly, okay?
Yeah, that'd be fine.
Okay. All right, thank you so much.
Thank you very much. You have a nice day.
All right, you too, Mr. Folsom.
Thank you, Your Honor.
Welcome. All right, the court is calling 2025 CR 010135 State versus Ashley Jones. Could I have parties announced for the record?
Austin Stott for the state.
Offer Ms. Jones.
And are you Ashley Jones?
Yes.
All right, the defendant is appearing by Zoom. Ms. Jones, do you understand you have a right to appear in person?
Yes.
All right, did you review a document with your attorney entitled Consent to Appear by Video Conference?
Yes.
All right, the court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Jones, did you review the application for deferred adjudication with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, the state's moving to waive counts 1 and 3 and proceed only on count 2.
Any objection?
No objection.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And when I say sign it, I mean electronically. Did you sign that?
Yes, ma'am.
Did you understand and the count that the state is proceeding on? You're charged with possession of a controlled substance, penalty group 1B, 4 to 200 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, do you need a cough drop? No, I need water. Water? Everyone, just give us a moment. All right, we're back on the record. Counsel, has your client been able to provide you with any defenses?
Honor.
Counsel,
Yes, ma'am.
has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. There's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 CR 002139, 2025 PF 16973, and there's to be the felony anti-theft course. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending your community supervision be for a term of 4 years. There be a TAP evaluation, 100 hours of community service restitution. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged and count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
The state offers State's Exhibit 1 and all attachments.
No objection.
All right, state, you may be excused.
Thank you, Your Honor.
Ms. Jones, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Do you have any children? Ms.
Yes.
Jones? What are their ages?
Yes,
What are their
they are
ages?
16, 6, and 7.
And do they live with you?
Yes,
Are you employed?
yes.
What do you do?
I'm a dental assistant in dental front office.
All right. And who is Raymond Jackson to you?
My children's father.
And does he still live with you?
No, ma'am.
All right. This is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 40 days, no employment as a home health care provider or with minors, field visits 1 time per month until further notice, and probation. I know she's seeking transfer. See if they'll do field visits. There's to be a transfer to Cobb, and I think that's COBB, maybe. Is that how you spell Cobb from Georgia?
Yes, ma'am.
Yes, that's correct.
All right, so Cobb County, Georgia. Take in consideration 2025 CR 002139 and 2025 PF 16973. There should be 100 hours of community service restitution. Once parenting classes are completed, the court will deem that satisfied. There's to be no contact with Raymond J. Jackson. There's a $1,500 fine. That will be probated. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
I just have a question in regards to the contact with Raymond Jackson. If we share minor children, what would be the stipulations in regards to the contact with him and the children?
All right, you can do that through a parenting app.
Okay.
All right, probation, contact with Mr. Jackson through a parenting app only.
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, from here on out, everything that you do in your life, you need to ask yourself whether that will have a negative impact on your children. This case, you're looking at 20 years if you don't successfully complete it, and if a motion to revoke is filed. Do you understand?
Yes.
All right, I'm going to send you to a breakout room. Probation will go over your conditions with you.
Okay, thank you.
Thank you. All right, who is here on Michael Anthony Garcia? And there are no applications? Court is calling 2024 CR 0090-02, 2025 CR 012431, State versus Michael Anthony Garcia. Can I have parties announced for the record?
Don Trevino for the accused.
And Megan,
Yes, sir.
if you could confer with the defense counsel on this. I think you're the attorney who's on it. Thank you. All right, counsel. And each of the cause numbers, have you received all discovery?
Yeah,
And did you review it with your client?
excited.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Garcia, in each of the cause numbers, did you have a chance to review the true bill of indictments with your attorney?
I looked at them, yes.
All right.
But
So-
I was under the impression I had a different attorney. When I went to the PR, they told me Michael De Leon.
No, this
Because
is your
when they came to
attorney.
Work with him the first time, I told him I didn't want him to be my attorney.
Well, this is your attorney,
I
counsel.
was satisfied with his service.
Well, he's your attorney. Do you understand?
I'm satisfied with I want to withdraw my plea. Because the indictments are incorrect anyways. I've never been convicted of a manslaughter. And it says I've been convicted of a manslaughter on there. I wasn't in possession of a gun. It was in the glove box of a car that's not even in my name. That I told him I would sign a statement saying that the gun belonged to the owner of the car.
No, so here's the thing. And I'm gonna explain some things to you. Owning a weapon, if you have a prior felony, it's not so much whether you own a weapon, it's whether you're in possession of it. And it doesn't matter when you went to prison. If you went to prison, you're not allowed during specific timeframes, during anniversary dates, you're not allowed to possess a weapon.
I was a minor, 1989.
All righty. Well, I mean, what are you talking about? What was from 1989?
The gun and the manslaughter that they're talking about. I was a minor. I was a juvenile.
So you are the person with the voluntary manslaughter. It was just when you were 15.
No, I never had one.
You just
That's
told me you did.
correct. That's what I said, what they're saying I had. That's wrong. I've never been convicted. So that indictment's not even correct.
You just told me that's who you were.
No, that
You
was
said when
not-
you were
that's-
15.
I said when they said I was 15, I was 15 years old, but they're accusing me of that. But I never went to court for that. I've never been convicted of that.
And the state's waiving that paragraph.
I did waive that, Your Honor, so
That's
I'm
from
not sure.
Cleveland, Ohio. That's not even from here. That's from
So
over 20 years ago, man.
I understand that, I waived it. So we're not accusing him of having been convicted of a voluntary manslaughter. We
Well, they're gonna
did,
give me a chance for probation, but everybody else had the same cases. I'm listening to them today, the 2nd-degree felony, and you're giving them probation and deferred beautification. I haven't been in trouble in 20 years. I'm 52 years old. I go do 10 years, I'm probably won't even make it out alive because of all the gang in the prison. I've never been in trouble in Texas. Never. Never, man. But you won't give me a chance at probation, but you give everybody else that has a long record a chance at probation. And they have the same cases as mine.
All right, so I'll tell you this, Mr. Garcia. What I do know is you can't compare your case to somebody else's case because you don't. But here's the thing, you don't know what evidence they may or may not have had with that person because every case is different. Sometimes people will say, I can't believe this person who is charged with a murder got 5 years and here you are offering me 40 years. It's because every case is different. And I understand that sometimes people have changed their lives, right? And they want people to recognize that they've changed their lives. But I'm just dealing with cases before me. Either I'm going to follow a plea agreement that you all have reached, or either I'm not going to follow the agreement. That's where we are. So, Mr. Garcia, the indictments are to tell you what you're being charged with. So in 2024 CR 0090-02, you're being in charge with unlawful possession of a firearm by a felon. And in 2025 CR 012431, there are 2 counts. The first count, you're being charged with manufacturing, delivery, a controlled substance, penalty group 1, 4 to 200 grams. Count 2 is possession of a controlled substance, penalty group 1, 4 to 200 grams. What I can tell you is when you have just, this is what I want you to do. This is what I want you to do. I want you to listen, okay? This is just what you're charged with. Now, The state and the defense may come to an agreement to say, this is what you're charged with, but we're going to go on a lesser included offense. Or they may say, this is what you're charged with in counts 1 or count 2, but we're only going to proceed on count 2. What I'm telling you is I haven't even got to the point of what your plea bargain agreement is. I'm just showing you the indictments. This is what you're being charged with. Do you understand?
Yes.
And counsel, did you go over the indictments with Mr. Garcia and explain it to him? Do you waive the reading of the indictment? State, in the cause number 2025 CR 012431, which is the drug case, are you proceeding on the indictment as presented?
We are not, Your Honor. We are waiving count 1, which is the Mandel count, and we are only proceeding on the possession count.
All right, any objections to the waiver?
None.
And then in the cause number 2024 CR 0090-02, which is the weapons case, are you proceeding on that indictment as presented?
We are not, Your Honor. We are waiving both of the enhancement paragraphs and proceeding only on the allegations contained in the jurisdictional offense, unlawful possession of a firearm by a felon.
Any objections?
No.
Now, Mr. Garcia, I'm going to show you the court admonishments. These documents tell you what your rights are, and it also contains in it what your plea bargain is that you have negotiated with the state. Now, because you've negotiated a plea bargain agreement with the state, that doesn't necessarily mean that I will follow the agreement. I'll have to read the stipulations and everything else. So in 2024 CR 00902, I'm sorry, 90-02, you're charged with unlawful possession of a firearm by a felon. That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. In 2025 CR 012431, you're charged with possession of a controlled substance, penalty group 1B, 4 to 200 grams. That's a 2nd-degree felony. The range of punishment is anywhere from 2 to 20 years with a possible fine up to $10,000. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Good.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you're giving up those rights? And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yeah.
Counsel, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Okay.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
All right, if you're not a US citizen, by entering into these pleas, you will be deported, denied naturalization, or re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause numbers, did you review the plea bargain page with your attorney? Did you understand it? In each cause number, your punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. The cases will run concurrently. The state is taking in consideration 2025 C 011469. Did you understand that to be the plea? Defense?
Yes.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraphs with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
None.
And cause number 2024 CR 0090-02. How do you plead? Guilty, not guilty, or no contest? And cause number 2025 CR 012431. How do you plead? State, any evidence?
In both causes, Your Honor, the state offers into evidence states exhibit 1 and its.
Right, in each cause number, did you review the waivers and stipulations? Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand, in entering these pleas, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you waiving PSI?
Yeah.
Anything you wish to say on behalf of your client?
Other than that, the previous convictions were 20 years ago.
Here. Now, Mr. Garcia. On the drug case, I read the police report, and in the police report, you had the drugs in your pocket. Yeah, so I mean, in the drugs you had in your pocket, the weight of the drugs was 28.564 grams. So, I mean, here's the thing. I understand nobody wants to go to prison, right? But you're gonna have to start doing the right thing. So in cause number 2025 CR 012431, the court will find you guilty. The court will sentence you to 10 years. Give you credit for any time served. There's a $1,500 fine, time and money to run concurrently. Taking consideration 2025 CC 011469. And this will run concurrent with 2024 CR 0090-02. And then in the other cause number, you admitted that there was a weapon in the vehicle. Yeah, I mean, you told the police, yes, there's a weapon in the vehicle. So that's care, custody, and control, and you're considered to be in possession. And you're not allowed to do that because of your criminal history. So in cause number 2024 CR 00902, the court is finding you guilty. Court will sentence you to 10 years in the prison, give you credit for any time served. There's a $1,500 fine. This will run concurrent with 2025 CR 012431 and 2025 CC 011469 will be taken in consideration. Is there anything else, counsel, with regards to sentencing? And each cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Oh, I'm, the county court, you'll have to take it there. They don't want us signing.
Which 112? Okay.
Yes. Well, yeah. All right. Did you review the trial court certification tells you whether or not you have the right to appeal? Now, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question of what that is, you need to speak to an attorney. Do you understand? All right, we can go off the record, Mr. Garcia. If you don't start making better decisions, you're going to find yourself living at the prison. You understand? All right, good luck to you, sir. Thank you, attorney. All right, thank you, Fernando. All right, who's your client?
Antonio Garcia. Garcia.
All right, come down. All right, so there's a warrant been issued because the court was in receipt of the 11th violation report from pretrial services.
Yes. And just to clarify something real quick.
Okay.
Mr. Garcia is not my client. He is represented by Luis Martinez, who could not be here this afternoon to be
Okay.
able to address the violation report.
Okay,
Just so you know, I did, he filled me in as well as a prosecutor filling me in, and I have spoken to Mr. Garcia
Mhm.
and explained the situation, and he is okay with me standing in for Mr.
Mhm.
Martinez right now.
okay, and then the warrant was issued because was he here on time or something?
He was here on time, is my understanding. However, there was a positive for cocaine
Mhm.
drug tests that came through the lifetime recovery and
Yes.
to the violation report.
Okay. So this is his 11th violation report.
I understand, and the only thing that I don't have, the only information I don't have is the 10 prior violation reports. However, I did confer with the prosecutor. There does seem to be a real and legit drug issue that that Mr. Garcia does need to address, and he does want to address. The concern that we'd like to bring to the court right now is allowing him to be out on his monitor, maybe even changing it back to partial to allow him to continue to work while he is waiting to get into a facility. It's my understanding that there will be two different options. Either he can go into lifetime inpatient. However, when I spoke with the CLO, she does not know how long that wait will be. However, I did confer with Mr. Garcia, who tells me he is full-time employed with benefits. His benefits are going to include medical and dental, so he does believe that there may be a inpatient treatment available there. So we're asking simply that he just be able to continue working until he can get back into inpatient treatment with a stipulation of 30 days to register for the treatment, shorter time if the court wishes, and then the GPS monitoring with continued drug testing.
Judge, so I would just request that, and I can speak to the last violation report. I believe it was because he did test positive and a urinalysis. And so for us to all address that, that's why he did take initiative as part of the court order as well for him to go to lifetime recovery. But I think at this point, he does need to be in custody and residential treatment.
All right, this is what's going to happen. You're going to remain in custody. We'll have you brought back over, and Mr. Martinez should be here.
I understand, and that was actually going to be my fallback, is if the court was not willing to go based off of the arguments that Mr. Martinez provided to me, if he can come back tomorrow to actually make the arguments with more information to the court.
All right, you'll need to speak to the deputies because there's a cutoff to ordering people.
Okay.
And so they have to be processed, but at the latest, it will be Wednesday. I'm sorry, Thursday.
Thursday.
Yeah. Why does it seem like today's long?
It's a long day. I agree, Your Honor. So I'll speak to the deputies, and if we can just have Mr. Martinez be able to appear on
Yeah.
Mr. Garcia's behalf.
Yes.
Okay.
All right. Thank you. Yes.
I'm the breadwinner at the house.
Mhm.
And I simply request to not put me back to the bail process. I'm trying to make a withdrawal from my 401k, so at least my wife and kids, if I have to do any amount of time, they can at least be covered. I'm more than willing to go into the inpatient treatment. I'll turn myself in tomorrow, come to your court tomorrow. That's God's on God's promise. I just simply want to know so I can have peace in my heart that they.
Oh, they're going to bring you back over tomorrow. Here's the thing, Mr. Garcia. This is what I don't think you understand.
Yes.
The last time you use may be the last time you use. And then you know what would end up happening? I will feel bad. And you know why I would feel bad? Because I would have sent you off into the world knowing that you can't stop using on your own. So what I can tell, but here's the thing. They're going to bring you back tomorrow.
The thing is, I want them not to lose the house.
Well, I mean, if they bring you back tomorrow, they shouldn't lose the house if you come back tomorrow.
Per se.
Okay, they'll bring you back tomorrow. All right, Jimmy Vara. Court is calling 2025 CR 011604 State versus Jimmy Vara Jr. Can I have parties announced for the record?
Sure. Teresa McBath.
Are you Mr. Vara?
Yes, sir.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Var, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, state is moving to waive paragraph B and proceed solely on paragraph A. Additionally, the name order Jimmy Vara Junior, I believe in the indictment is Jimmy Junior Vara, so the court could just move the junior.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with burglary of a building. That's state jail. Felony range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. That you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Zavar, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
By entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishments to be assessed at 2 years in the state jail facility. There's a $1,000 fine and the state recommends community supervision. Did you understand that to be your plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and did you sign it?
Sure.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years, that there be no contact with Luis Montemayor. Recommendations from the state, and the court does not have to follow those recommendations.
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor, state offers states exhibit 1 in all attachments.
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
What's going on in your life? Why are you committing burglaries of a building? Why are you walking around with a trash can like you own the home? Why are you going on the side of somebody's home using their water to wash yourself? What's happening?
I was just pretty much just going around the neighborhood, and I was told about doing some landscaping work, and they had told me about a place where
you can just go over without permission, wash, grab somebody's lawnmower that is not your own, and take it. Who told you that? I don't think anybody told you about a landscaping job where you can just go to somebody's home that you don't know, take their equipment, and wash up with their water hose, and then just take their lawnmower down the street.
Oh, the job was something else, but the person that told me about the place was saying, no, it was no good.
They just told me about the spot so I can get the lawnmower to go
Mhm.
and make some quick money.
So how often have you been using
Sorry?
drugs? When have you been using and what have you been using and how often?
Um, maybe like 8 years ago. Wow.
Here's the thing, you need to be honest with me because I'm trying to figure out what conditions to set for you. So how long have you been using and what have you been using?
Oh, I'm sorry. 8 years ago, it was methamphetamines and heroin.
All right. And when's the last time you used? And it wasn't 8 years ago if you're doing this because this is from 2025. This offense.
Yes.
So
My last few years. Well, 8 years ago. I was just to make some quick money.
all right. So do you have an answer for me or no?
Yes, Your Honor.
Yes.
When I got incarcerated.
All right. Do you have any children?
Yes, Your Honor.
What are their ages?
14 and 16.
When's the last time you had any contact with them?
It would be like maybe six months ago.
All right, this is what the court will do. Court will sentence you to 2 years in the state jail facility, suspended and probated for 4 years, regular reporting by Zoom or in person, regular random UAs, 120 hours of community service, restitution, parenting classes. Once that's completed, the community service hours will be deemed satisfied, $1,000 fine, probated, no contact with Luis Montemayor or 267 Pendleton, the MRT, TAP evaluation in custody, follow recommendations, no contact with minors, no residing in household with minors, proof of employment within 45 days, no employment as a home health care provider or with minors, and a referral to felony drug court. Probation, is there anything else? Is there anything else you need?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, good luck to you.
I'm sorry, Phil visited.
Phil visits 1 time per month until further notice. Thank you.
All right, sorry again.
Michael Garza. There's no application. Look at that. What, are we gonna stay here and spend the night or something? Court is calling 2025 CR 010881 State versus Michael Robert Garza. Can I have parties announced for the record?
Melissa Alba, State.
Teresa Max Vasquez for the defense.
And you're Mr. Garza.
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Mr. Garza, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are.
Mr. Garza, did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you cite it in all the appropriate places?
Yes, ma'am.
All right, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. Normally, that's a state jail felony. However, the state is proceeding on the repeater enhancement allegation. If that's proven to be true, then your range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow the plea. The court does not have to follow the plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept I'm sorry, just one moment. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. You'd agree that you've been previously convicted of 1 or more felonies for enhancement. There's a $1,500 fine, no applications. Take in consideration 2025 CR 010881, and there's to be no contact with Macy's. Did you understand that to be your plea?
Yes, ma'am.
Defense? Defense, is that the plea?
Judge, I believe you have to take into consideration, I'm sorry, Judge.
Oh, my apologies.
No problem.
Just want to make sure.
Okay.
Okay.
And take in consideration 2025 CR 010884. Did you understand that to be the plea?
That's correct, Judge.
That's correct, John.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
To the enhancements, how do you plead? True or not true?
True.
State any evidence to support the defendant's plea.
State Office into Evidence States Exhibit 1 and it's.
No, Judge.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Court will sentence you to 2 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's to be no contact with Macy's. Take in consideration 2025 CR 010884. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Make better choices. You're going to find yourself in prison for the rest of your life, okay?
Yes, ma'am.
Good luck to you.
Thank you.
All right, the court is calling 2025 CR 007617, State versus Noel Elliott. Can I have parties announced for the record for the state? And are you Miss Elliott? Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Elliott, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Elliott, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right.
Your Honor, like, if I may, just for the information for the court, she had gone through a competency evaluation,
Okay.
found to be competent. We
Okay.
were at the Metro State Court yesterday,
Okay.
and the report has been filed.
All right. And was she actually Was her case actually heard in magistrate's court?
Yes.
Okay. All right. So let me slow it down a little bit. So the true bill in the indictment tells you what you're charged with. Did you get a chance to review that with your attorney? And did you understand it?
Yes.
Okay. Counsel, are you waiving the reading of the indictment?
I am, yeah.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Ms. Elliott, did you review the court admonishments?
Yes.
With your attorney, did you understand it and sign it in all the appropriate places? Did you? Yeah.
Just taking it down, say it out loud, yeah.
Yes?
Yes.
You're charged in each count with robbery. Those are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into plea bargain agreements?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years and up to a $10,000 fine in each count?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, sir.
Do you believe she's currently competent and was legally sane at the time of the offense?
My opinion is.
Ms. Elliott, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Did you understand if you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on counts 1 and 2. There's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, no motion, John.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 200 community service restitution hours, no contact with the Dollar General store, Krista Mata, Kristen Brandon, Jeremy Abbott, a mental health evaluation, and to follow the recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then how do you plead to count 1, guilty, not guilty, or no contest?
No contest.
Count 2, how do you plead?
No contest.
State any evidence?
Your Honor, state offers states one in attachments, and then I just do have one thing to add. That was our agreement. However, I just realized that the defendant caused a resisting arrest, so I was just gonna put on the record that I'll go through TIC that.
All right, and what is the cause number that will be taken in consideration? Any objections to
No
that?
objection, yeah.
Okay. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yeah.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty in each count. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Not yet. Yes, sir.
Anything you wish to say on behalf of your client?
Your Honor, my client just at this point take into consideration that when it comes to court costs, I mean, not court costs, but you know, the fees and everything that you have to pay. At least right now, she's homeless. Okay, and she has no job, so I don't want her to get into trouble
she probably is going to have to go to Haven for Hope and ask for assistance. I don't want her to set her up for failure in her probation. And I'm asking the court for any kind of assistance.
All right, so what's going on in your life? Why are you stealing from the Dollar General?
Made a poor decision. And it's just so unlike me and really, I just don't know.
So where is your
I'm a
family?
Responsible person, have it all together, but. So I'm gonna need to look for employment and.
My question is, where is your family?
My family is in Plano, Texas. My mom.
Do you want to be transferred to Plano, Texas?
We would prefer that, yes.
What county is that?
I'm not sure.
Does anybody know Plano?
I'm not sure, Your Honor.
I'm sorry, what? Spell that, please.
COLLIN.
All right, so transfer to Collin County. All right, have you ever used any type of drugs in the past?
No,
So what is your mental health diagnosis?
it's schizoaffective, bipolar schizoaffective.
She is on medication presently, I believe, Your Honor.
All right, do you have any children?
Yes.
What are their
I have
ages?
3. I have 2 10-year-olds and a 2.5.
All right, and where are they?
They're with our adopted parents.
Okay. This is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication in counts 1 and in count 2. Counts 1 and counts 2 will run concurrently. There's to be regular reporting by Zoom or in person, regular random UAs, $1,000 fine probated, taking consideration 2025 CC 005302, 200 hours of community service restitution. I'll order parenting classes. Once she completes that, the community service hours will be deemed satisfied. No contact with the Dollar General store. Christia Mata, Christian Braden, Jeremy Abbott. There's to be a transfer to Collin County, a MIC evaluation in custody, proof of employment within 45 days of release, no employment as a home health care provider or with minors, TAP evaluation in custody, follow recommendations. If Plano has field visits 1 time per month for 6 months, there's to be no residing in households with minors and no unsupervised contact with minors. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. All right, we can go off the record. Here's the thing. This is going to be very difficult for you because you don't have a place to stay yet. You're being transferred to Plano. When you get transferred to Plano, you need to make sure you stay in contact with your probation officer. If something happens, you can't reach them, you can always call back for this court, okay?
Okay.
All right, good luck to you.
Thank you very much.
You're
Thank
welcome.
you, Your Honor.
You're welcome. Antonio Vasquez. Court is calling 2025 CR 009727, State versus Antonio Vasquez. Could I have parties announced for the record?
Lauren Espinosa for the state.
Christopher Ramos for the defense.
Are you Mr. Vasquez?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
I did and I have.
Court will find that the state is in compliance with discovery. Mr. Vasquez, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the repeater enhancement allegation and additionally proceed on the lesser included offense of criminal trespass of a habitation.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? State is proceeding on the lesser included offense of criminal trespass of a habitation. That's a Class A misdemeanor. Range of punishment is up to 1 year in the Bear County Jail and up to a $4,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? You need to speak up.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Vasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you may be deported, not allowed re-entry or naturalization. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 168 days in the Bear County Jail. And they are saying that the judgment is satisfied. Do you understand that if you don't have 168 calendar days, then I cannot give you a judgment satisfied? Counsel, is it 168 days, calendar days?
Per the recording from the clerk.
All right. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there being such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? I'm sorry?
Contact.
State any evidence?
Yes, Judge, state offers states exhibit 1 and all attachments.
No, Judge.
All right, and state, have you had a chance to speak with the complainant?
Yes, Judge, I did on Friday.
All right, thank you. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge. Please.
Court will sentence you to 168 days in the Bear County Jail, give you credit for any time served. The court will notice the judgment satisfied, and there's to be no contact with Maria Ramirez. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. Stay away from her.
All right. Thank you, ma'am.
You're welcome.
Thank you, Judge.
You're welcome. Deputy Laura, are you all gonna beat it? All right.
Thank you, guys.